All right, we may begin.
Right. Good morning, Ms. King. Um,
Morning.
in reference to your testimony on direct examination yesterday, you stated that Mr. Maynard did not attend IAV's recent award ceremony. Is that correct?
That's correct.
And did you send Mr. Maynard the information regarding that award ceremony?
I would have had to because he asked for photos of it.
Okay. But you did not tell him the details of it, correct?
I'm not sure what you mean by the details of it with him asking about, photos from her program. He would have had to, I can't remember the details surrounding it.
Okay. And let's discuss fall break just a little bit. You kept IAV for fall break of last year, correct?
Yes, ma'am.
And this year you showed up for Mr. Maynard to exercise fall break with IAV, correct?
I did.
However, your parenting plan states that fall break is to be defined as a duration of consecutive days in September or October. Is that correct?
It does.
And in R29, you showed that IAV school calendar for last school year did have a 1 week fall break, correct?
At that particular school, yes, ma'am.
And that is the break that you exercised last year.
Last year, yes, I did.
But IAV's fall break for this school year was only 1 day. Is that correct?
No, ma'am. It was the Friday and the Monday.
Okay, so the Friday and the Monday, did you inform Mr. Maynard that it was the Friday and the Monday?
Several times as he was texting into the midnight hour, I let him know that it was a 4-day break. It was Friday, Saturday, Sunday, and Monday. So the consecutive days. Yes, ma'am.
Okay. But you did not communicate to Mr. Maynard that you were on your way to the meeting place that night on Friday, correct?
I didn't. We never really do. We follow the parenting plan, and especially with the concerns he had last year about not receiving his parenting time, I definitely did assume that he would be there at that time. So I didn't feel the need to communicate.
You assumed that he would be there, so you did not communicate. Is that what you're saying?
I understood that the parenting plan stated it. Therefore, I assumed that he understood the language in the parenting plan, just as every other holiday or breaks or things like that, that the holiday situation and schedule will be understood based off of the parenting plan.
Um, the on this particular fall break of this year, Mr. Maynard was not able to get IMV until 7:30 the next day, correct?
Which would have been his regular time. Yes, ma'am.
Okay. And he did show up at that time, correct?
Yes, he did.
So, in reference to your current parenting plan, again, you stated on direct examination that Mr. Maynard and you agreed to the terms of that parenting plan. Is that right?
Yeah,
You also stated that at the time you did not know where Mr. Maynard lived. Is that correct?
that's correct.
And he did not know where you lived either.
That's correct.
Yet you both agreed in your parenting plan to provide one another with your respective addresses upon the entry of that plan. Is that correct?
That I believe was in there. Yes, ma'am.
Okay. And you also stated on direct examination that Mr. Maynard did give you an address, but it was missing a unit number. Is that right?
Yes, and of course, when he had IEB at that time, it proved that that address was futile because without the apartment number in a huge apartment complex, that really doesn't mean anything.
But Mr. Maynard did in fact attempt to provide you with an address, correct?
A street address, but not his home address. No, ma'am.
Um, so as it pertains to your testimony on direct examination yesterday, you stated that the reason that you did not put Mr. Maynard's address on file with the school that IAB was enrolled in was because you had no address. Is that correct?
At her original daycare. So that's what I was saying. This has kind of been going for some time, of course. But when we first essentially started the daycares, I did not necessarily have an address for him at that time because he wasn't fully living in Georgia at that time. So once I did, have something, I put his name and provided him the paperwork for her schools so that he could put his own address and information.
But as a primary custodian, you did not put Mr. Maynard's address on file at Life Christian Academy, did you?
IEB started Life Christian Academy probably at about 1.5. Adrian wasn't fully transitioned into the state of Georgia at that time, so I didn't have an address to put for him.
But you stated in your interrogatory responses that IAB resumed attending a daycare in September of 2021, correct?
That would have been the same school, so it didn't require any new paperwork.
But you had Mr. Maynard's address as of September of 2021, correct?
That's what I'm saying. I didn't have the full street address, and at that time, it was the same school, so it didn't require any new paperwork or daycare, excuse me. It didn't require any new paperwork or anything new to submit. She started attending, and that was that.
Your Honor, if I may have screen sharing capabilities.
Yes.
Okay.
Yes, ma'am.
Ms. Maynard, I'm showing you what was admitted yesterday as Respondents Exhibit 22. Do you recognize this?
Yes,
Okay. And you testified to this particular text message yesterday on September 24th of 2021, where Mr. Maynard sent you his full address, including the unit number, correct?
yes.
So when IAB resumed attending Life Christian Academy, why did you not put Mr. Maynard's address on file since he had sent it to you completely?
This had been a daycare Abby had been attending since she was 1.5, like I said at this point. So after the COVID incident, because that's kind of what slowed her down going to daycare during those COVID times, when she did start going back, at that point, she wasn't required to refill out any new information. She just kind of resumed attendance at that place at that time, essentially. So there wasn't a need to put any new information. He knew where it was. And when he came to the school, he was given the paperwork directly, and he never filled it out for himself. So I said there was no need for me to fill out anything new, even on my side. She just started resuming attendance.
Okay. So given that Mr. Maynard did provide you with his address over 2 years ago, it is not necessarily true that you all have maintained a tradition of not knowing each other's addresses, correct?
Can you repeat that question?
Given what I just showed you, Respondents Exhibit 22, where Mr. Maynard sent you his address over 2 years ago, it is not true that the two of you have maintained a tradition of not knowing each other's addresses, correct?
Oh, that's when he was going through lawyers to start the case. So he only provided his address because his lawyers called me, and I let his lawyer at that time, representation, know I don't have his address. So he only provided it at that time because that was around the time of certain things starting litigation-wise.
But you just told me that in order for him to begin parenting time with Ivy shortly after the parenting plan was enacted, he had sent you an address and it was just missing the unit number, correct?
I can't say in order to resume parenting time, that wouldn't be correct, but he sent a street address at some point. Yes, ma'am.
Okay, so I'm going to ask you my question again. It is not true that the two of you have maintained a tradition of not knowing each other's addresses, correct?
I still say that that would be the case because even with that, Ivy was born in 2017. He didn't move to Georgia until Ivy was close to 1. At that point, he was in transition. There are messages where he stated, Ivy's safe with me. You don't need a specific address. And while he provided something, a street address, that can't really count as an address because if I went to go look for her, if something happened or anything to that effect, I would never have any access to her without the unit number. So that really, that's not really an address.
You know what kind of car Mr. Maynard drives?
I'm sorry?
Do you know, I'm asking Ms. King, do you know what kind of car Mr. Maynard drives?
I see a Nissan at the pickup, a Jeep at the pickup.
And if you saw those two cars somewhere else, would you recognize it again?
I would, yes.
Okay. In Respondents Exhibit 15 that was admitted yesterday, you explained that Mr. Maynard became very upset during that conversation that you all were having, correct?
Can you refresh me of which one was 15?
Yes, no problem.
Yes.
Respondents 15. And you explained that Mr. Maynard had become very upset regarding this conversation specifically, right?
Yes, that's one of many times that he became very upset.
Okay. And at page 5 of these messages, Mr. Maynard sent you this message in gray, correct? That says, keep your personal life and our child separate.
Yes.
Was this before or after your divorce?
Can you show me the date again? Look like 2018 from what I saw. So that would have been before.
Yes, April 13th of 2018.
Yeah, so before.
Okay. So before your divorce, Mr. Maynard expressed to you that he wished for you to keep your personal life and Ivy's life separate, correct?
Yes.
You stated that prior to your divorce, you and Mr. Maynard had discussions about the polyamorous lifestyle. Is that correct?
That's correct.
And you specifically used the term dating other people. Is that right?
I believe I used that term. Yes.
Okay. But based on what I just showed you in Respondents 15, Mr. Maynard expressed also before your divorce that he wished for you to keep your personal life and Ivy separate, right?
It's a little fast. I'm trying to understand your questions. Give me that again.
All right, no problem. I'll slow down. Based on what I just showed you in Respondents 15, Mr. Maynard expressed that he wished for you to keep your personal life and Ivy separate, right?
Yes, he stated that in one of his angry rants. Yes.
And he had, in fact, consistently expressed that he did not agree with the people that you dated being around Ivy, correct?
That's a very interesting point, to state that he had an issue with who I had Ivy around, while him also being open that he had Ivy around certain people. There were posts on social media that I saw with Alexa posting with Evie. So, I mean, it's kind of one of those almost jealous things that I really didn't pay much mind to, honestly.
So is that a yes or no to my question that Mr. Maynard had expressed to you that he did not wish for Ivy to be around the people you dated?
He expressed that, yes.
Okay. And is that why you did not tell him that you and Ivy were living with people at the time that you all consented to your parenting plan?
You said, is that why?
Yes, because he had expressed to you that he was not comfortable with it. Is that why you withheld that information from him at the time that you all consented to your parenting plan?
I can't say that's why. Like I said, we didn't share information like that about our personal lives, honestly. At that point, we were separated. So it wasn't anything that I just didn't tell him because of something. Neither of us shared information in that way.
But you knew about Alexa, correct?
I knew of, I didn't know the details. Like I said, I didn't know as far as living with or when or what. Like I said, I started in my own apartment. So once I can't say it was any reason of not. Like I said, we just didn't, honestly. We were divorced at that time or separated at that time. I'm sorry.
Okay. You bring an interesting point that you were actually starting out in your own apartment at the time of the divorce, correct?
I started out in my own apartment. Yes, right after Abby was born. Yes.
Okay. Going to show you your interrogatory's responses that's been previously marked as Plaintiff's Exhibit B. Do you recognize this document?
Yes.
Are these the interrogatory responses that you provided to my office on January 27th of 2022?
It's scrolling kind of fast, but I'm thinking so. Yes.
I'll scroll slow.
Okay. Yes, it is.
Okay. And is this a true and correct copy of your interrogatory responses at January 27th of 2022 as you knew them to be?
I do believe so. Yes.
Your Honor, at this time, I move to admit Plaintiff's Exhibit B into evidence.
Plaintiff's B.
I can't hear. Plaintiff B as in boy.
I'm sorry, V as in Victor.
Oh, V as in Victor.
B. Okay.
I would, Judge, I would object on the ground of relevance. Now, if counsel is using this for purposes of just asking her questions to impeach her, that would certainly be admissible and relevant, but to admit an entire interrogatory response when there are some statements that may not be relevant, I would object to the admission of the entire document.
All
I
right.
don't see why her interrogatory responses would be irrelevant in this matter.
What
Well,
now?
if she
I
was
don't see
asking
why
questions.
discovery responses are not relevant in this matter. They
What's the relevance then?
I'm going to interrogatory response number 5, where Ms. King discusses her past addresses that she just testified to.
Okay, and you're doing that for what purpose?
For the purpose of 1, impeachment, but 2, also explain the fact of how many addresses she had, which is my next line of questions.
Okay, so for impeachment purposes, I'll allow it.
Okay. Ms. King, at interrogatory response number 5, interrogatory request number 5, I'm looking at the non-bolded paragraph. It asks you to please list all the addresses that you have resided in since your divorce from the petitioner in this matter, including the dates of your residence. That is the first sentence, correct?
Yes.
And the first address that you listed here states that no other individuals lived with you at this address, correct?
Right.
And then the next address you listed that Melody King began living with you, correct?
Yes.
And then at the next address, you also listed Ms. King, correct?
Yes.
And then at the 4th address, you listed Ms. King, Ms. Walker, and Mr. King, correct?
Correct.
Which means that your living situation has changed at least 4 times since your divorce from Mr. Maynard, correct?
No, ma'am. And I think that's something that I definitely would love to speak to, because this conversation or this document would have been since the divorce. Those addresses are from 2017. That's over a span of 6 years total. So that definitely is not since the divorce. Absolutely not. I lived in the apartment in 2017, and I was visiting, or not visiting, or Evie was going to visitation and seeing her dad, of course, with Melody at that time. And I was living with Melody far before the divorce. That was known and aware of. These addresses aren't after the divorce. So that's definitely my mistake for sure.
So you listed incorrect responses to interrogatory request number 5.
I didn't understand that that was since the divorce. So I did list incorrect information. I did. That's my mistake for sure. That's not since the divorce at all.
I'm sorry, when were these interrogatories for? Was this divorce interrogatories or?
No, these are modification and contempt interrogatories in this matter. Were submitted in January of 2022.
Okay, okay, got it. All right.
Yeah. So the question was since the divorce, and I misinterpreted that. Those addresses date back to, I had Ivy in 2017. So that's not correct. No, ma'am.
So which one did you live at since the divorce? Where does that start on this list?
The Malvern address.
Okay, so from Malvern to Field Green, 2 more people moved in with you?
From Malvern to Field Green. And that move in, that she stores her things in the basement. So even that is not a live with, but Melody and then Terence as well.
And Melody had a daughter too, correct?
Melody's daughter resided with her father.
But she did reside in your home at times as well?
No, ma'am, that's not correct.
Okay. You also testified yesterday that T is currently living with you or staying with you. Is that correct?
She's getting on her feet for a moment. So she's visiting. She was actually supposed to be going last month, but she needs a little bit more time.
But she did not live there at the time of your divorce, correct?
No, she doesn't really live here now. Like I said, she just needs a place to get on her feet, essentially. So it's not a permanent or anything like that. She just needs she was in the process of getting evicted and honestly needed a place to stay.
Okay. And T also has a son, correct?
She does.
And he stays there too as well?
Yes, he's one of Evie's friends since they were born. They're classmates. Schoolmates. They go to school together.
But you did not mention him in your interrogatory responses or yesterday during direct examination, correct?
You said in my interrogatory, the case has been going since 2021. So she wasn't there then. This is probably within the last maybe 2 months. And yesterday I did mention T. I'm not sure if I mentioned Elias.
And you stated that Ms. Walker is just storing her things in the basement.
Yeah, the basement is actually almost like its own apartment kind of thing. It has its own entrance, no real connection to the house. She just stores her things there. But I did want to be forthcoming and let someone know that, she does store her things here, not reside.
So since the divorce, Ms. Walker has come and gone. Is that correct?
That wouldn't be correct terminology. She's always maintained her own apartment. She's never lived or come or to gone. She comes to get her things, and that's that.
So she stores her things there, but she has a place of her own.
She's always maintained her own apartment. She's always lived downtown Atlanta somewhere, has always had her own place. She uses it more as a storage unit of sorts. And Monique has never been a part of the relationship at all in no way. So that's definitely a storage situation.
You stated on direct examination, and you also just told me recently on Cross that Mr. Maynard did not complete the school forms for IMV that you provided him with, correct?
No, at
But
neither the daycare or choice preparatory, no.
Okay, but you had previously informed Mr. Maynard that you were going to be homeschooling IMV, is that right?
That's a term that's used. Like I said, she wasn't school age until 5. So it's a loose term during COVID times when daycares are shut down. Like I said, I taught her to read at 3. I taught her basic math skills, those kind of things. But I can't say homeschool because she wasn't school age.
And is it true that Mr. Maynard had communicated with you about the forms regarding choice preparatory?
I can't remember what exactly he stated. I think that was in the same message as far as her acting, that he had to talk to his lawyers or still looking over it. I'm not 100% sure.
Do you recall these messages?
Yes, that's the ones I'm referring to. Yeah.
So the second paragraph here, Mr. Maynard stated to you that he had gotten the paperwork from choice preparatory, right?
Yes.
And he asked you for records from the other schools that you had listed in your discovery responses, correct?
Mm-hmm.
Did you provide him with those records?
No, I let him know that I couldn't get them after he came to the school and intimidated and harassed. And the director actually called the police due to his outburst, which was very, very obscene in front of the children. She ended up calling the police, and she stopped answering my phone calls as well. She would not provide any further records. She wouldn't give me anything. She was actually deposed, and she still, of her own accord, did not provide anything. So I couldn't get anything more from her.
So it's your testimony that it's Mr. Maynard's fault that you could not obtain IIV school records?
I would say after he came and, with the outburst, she no longer was interested in providing any information. And from what I recall, his attorneys actually called her formally to court, and she as well said that she'll be doing that. He went through paperwork and violated the sign-in sheet for the other children, was in her office rummaging through things. It just became very volatile. He refused to leave. She called the police, and she stopped answering all phone calls from that point on.
Were you there when this happened?
I was, yes, ma'am.
And you did not try to intervene, is what I'm assuming?
You say intervene? What would you have like me to do?
I don't have any suggestions. I'm just asking, did you try to intervene in the situation? Did you say, Adrian, they have the records? Did you do anything, or did you just stand there?
Well, if I recall, I believe you all provided a video where I showed that I would be getting him the records as soon as I got them. I let him know that I would, try to get what I could to him. But at that point, she stopped responding to phone calls. As far as I said, he was leaving after that and was there to pick up Ivy for her birthday weekend and walked off without Ivy. I did intervene then. I stopped him and reminded him that he was there to get his daughter, although he was leaving because he couldn't get information and left her as well. But that's to the extent of my intervention, just reminding him that he was there to spend time with Ivy, not on a information expedition.
Okay. You stated on direct examination that you have been the primary medical caretaker for IIV. Is that correct?
Yes, ma'am.
But Mr. Maynard has taken IIV to the doctor about her feet on multiple occasions, right?
Yes, ma'am.
In fact, you also stated on direct examination that you were concerned that the two of you were getting conflicting doctor's reports, correct?
I can't say concerned. I just didn't believe the doctor's reports.
So you did not believe Mr. Maynard's doctor's reports?
I don't think his doctors had a full picture. I can't say that he ever had a primary care physician for Ivy. From what I understood, he took Ivy to urgent cares and provided symptoms and information. But at the end of the day, there was never a primary doctor like Ivy has had with me. So I can't imagine how they would have a full history of that sort.
That Mr. Maynard has carried Ivy on his health insurance, correct?
That's correct.
And you stated on direct that Ivy has been a healthy child with a minor stomach bug or two. Is that right?
That's right. She's a kid. Sometimes she does get sick, but she's never had any major health concerns, no.
Okay. Ivy went to the doctor about her feet again this past summer, right?
He continues to take her to the doctor about this non-existent foot issue, yes.
Okay. I'm going to show you what's been previously admitted as Plaintiff Exhibit G. Do you recall saying this on day one of trial?
Yes, I do.
Would you describe this as no reason to take Ivy to the doctor?
I would say that's a blister. I would probably do a topical treatment. I don't see any bones or breaking. She was able to move her toe. It looks a little raw, but honestly, I would probably, if anything, get her a checkup, but definitely not urgent care in that case.
I'm going to zoom in for you a little bit here. Do you see the tip of Ivy's second toe here?
I do.
Do you also not think that this is a reason to take Ivy to the doctor?
That looks like dirt to me, so I wouldn't take her to the doctor for dirt. I would just wash her toes.
So you believe she only has dirt on one toe in this photo?
I do.
And this is not the foot fungus that Mr. Maynard has reported Ivy has had for the last 3 years.
No, he's been referring to that triangle pinky toe. That runs in my family. That on her long toe just looks like a little dirt. I said there was a period of time where she was going back and forth between wearing socks. So that's definitely not what he's referring to. He's referring to that pinky toe that he's saying is brittle and triangle shaped. And like I said, that's something that's hereditary. What you're referring to on her longest toe, it just looks like a little bit of dirt to me. I would clean it up, clean her nails and trim them.
And the blister that you see on Ivy's last toe, it's Mr. Maynard's contention that that's from Ivy wearing too small shoes. And you disagree with that?
I do. That was actually a situation where she stubbed her toe. She was running and playing, and although she had shoes on, I think there was a elevated partition of some sort in the building that we were in. She stubbed her toe pretty badly there. But no, that's definitely not from wearing too small shoes.
So when Mr. Maynard sent you this photo, why didn't you tell him that she had stubbed her toe?
I believe I did. I can't recall. Honestly, when it comes to communication with Adrian, nothing that I say is believed. Nothing that I say is resolved. There's just such disbelief. It has always been, I have to go above and beyond to get him to understand or believe. And it makes it clear that he never does or never will. So he saw it. I let him know that it can be treated. And, I just always try to reiterate that if there is a concern, I'm doing my part and he can do his. But I can't say that anything that I would say would be believed. He does not.
So you told Mr. Maynard that you see what he's talking about. It can be treated, but it's your testimony that it did not need to be treated by a doctor.
I mean, it's a blister, so I'm not quite sure what a doctor could do different than a Band-Aid and some, topical cream. It doesn't need stitches. It's a blister. It healed over within a week or so. So I'm not quite sure what a doctor would have done differently than, look at it. It wasn't infected. It's just a little bit red. I would have handled it topically for sure.
Okay. And when Ivy went to the doctor this past summer about her feet, Mr. Maynard informed you that the doctor had prescribed Ivy yet another prescription for an antifungal, correct?
He did.
Okay. And so although Ivy has been prescribed antifungals for her feet on multiple occasions, it is still your testimony that you do not believe that Ivy has any issues with her feet.
That's correct. Every time that I have taken her to the doctor, and even if he has taken her to the urgent care on Saturday, she's followed up with her general care or general primary physician on Monday. And I said, I don't see any athlete's feet because, again, his doctor or his urgent care, different doctors are diagnosing her with athlete's foot. That toenail is not anything to do with athlete's foot. She doesn't have any scales or any itchy skin or anything that's related to athlete's feet. So from what I understood from my general care physician, you can give symptoms and a doctor will prescribe medication, especially if it's something that they are saying has happened again and again, but it doesn't mean that that's actually the diagnosis. There isn't some signs of that outside of her pinky toe that's a little bit hardened.
Okay. You stated on direct examination that Ivy has recently decided to stop wearing socks. Is that correct?
She's decided to start wearing socks. She kind of goes back and forth. Like I said, I don't wear socks, so I'm not sure if it's something she saw me doing and just kind of picked up with. She goes back and forth, but I even had a conversation with Adrian at one of the pickups and let him know, like, I'll start, working with her as well, because it was something that was kind of clear that she, kind of, I guess, playing both sides with it, telling me one thing, telling him one thing, but ultimately, she's now wearing socks. She did not stop recently, no.
Okay. So during the time that Ivy was not wearing socks and Mr. Maynard was repeatedly taking her to the doctor about her feet and she was being prescribed medication, you did not at that time intervene and start making Ivy wear socks?
Well, when he's taking her to his urgent care doctors and her primary care physician doctor is not diagnosing her with any issues, then at that point, there's nothing that needs to be corrected. I'm not sure what information he was getting from urgent care, but like I said, on multiple occasions from her regular doctor, she was cleared. So there wasn't any changes needed.
Okay. I'm going to show you what's been previously admitted as Plaintiff's Exhibit F, as in Frank. You recall this exhibit, correct?
I do.
And if I recall your direct testimony yesterday, you stated that these are Ivy's play shoes, right?
Correct.
And Ivy had been having multiple issues with her feet, which is what we had just discussed, correct?
I can't say she's had multiple issues with her feet. Adrian has felt like she's had multiple issues with her feet. Yes, but she has not had multiple issues with her feet.
And so have the doctors that Mr. Maynard has taken her to. They've also agreed, correct?
The one-time urgent care physicians that just so happen to be there when he takes her to urgent care, although her general primary care has not, but yes.
So Ivy has been being taken to the doctor for the past 3 years about her feet by Mr. Maynard. And you testified yesterday that these are Ivy's play shoes, right?
Yes.
And I just showed you in the previous exhibit G, a photo of Ivy with blisters on her toes, correct?
Okay, yes.
And I'm now showing you a photo of Ivy's play shoes, correct?
Yes.
So would you not agree with me that Ivy's feet have been a consistent issue for the past 3 years?
No, I don't agree with that.
And you did not feel it was necessary to at least have Ivy wear socks after these recent issues?
Like I said, I feel like I've kind of answered this to the best of my ability. Ivy's primary care physician has never diagnosed her with any issues. She has play shoes where she runs and plays. She loves going to the park and running. So that's what you're seeing there. But the blister definitely has nothing to do with that. Like I said, she stubbed her toe, completely unrelated to the shoes as a whole. Her pinky toe is not any fungus. I can't say she has any foot issues. Those are just play shoes.
Have you applied the topical creams that Mr. Maynard has given you that the doctors have prescribed to Ivy?
So yeah, so when I returned her, when she was returned to me on Sunday, I did that for the first night following it. And then when I took her to the primary care physician, and she said that it's not necessary, I didn't want to give her unnecessary steroids and medicine. She's young. If she doesn't need it, I don't want to introduce anything more to her body. And her primary care physician confirmed she doesn't need it.
Going back to the socks one more time, you do recall regarding that Lydom's testimony on day 1 of this trial that Ivy had reported to her that she was told that she could not wear socks. Do you recall that?
I recall that. We were never asked about that. And I think when she came, we told her that that was something that wasn't true. But yeah, that's definitely not true.
Okay. Another ailment that Ivy has struggled with is that she has a recurring wart on her right eye. Is that correct?
Can't say recurring. We recently fully got it off and it hasn't come back.
Mr. Maynard brought to your attention in September when he took Ivy to the doctor about her feet. He also let you know that he noticed the wart on her right eye coming back, right?
I think coming back is a term that probably isn't the correct term in this case. During the treatments for her eye, when you put the medicine that the doctor prescribed on it, it will start to get a little bit longer as it dries out. So it may look like it's coming back, but it's really just in the process of falling off. So no, ma'am, it wasn't coming back at all. She was just in the middle of treatment for it.
But you just told me that you all recently got it completely removed, right?
Completely gone now, yes.
Okay. Ivy also broke her arm this year, right?
She did.
And she did that while she was at the park with Terence?
She was at the park, yes.
Okay. And did she get a pink cast for that broken arm?
She did. She loved her pink cast, purple. Every time she got a new one, she picked a new color. It was so cute.
Were you present when Ivy broke her arm?
No, that was a park that she went with Terence.
Okay. You stated that yesterday Ivy had burned herself on the air fryer, correct?
Yes.
And that has happened on more than one occasion, right?
No, ma'am, that's not correct.
It's only happened once?
Yes, and that was that slight little red mark, no blister, no nothing, size of a pea. It definitely did not happen more than once, no, ma'am.
Okay. I'm showing you what's been previously marked as Plaintiff's Exhibit EE. Do you recognize the hand in this photo?
That's Ivy's hand.
And did Ivy have this cast on in September of 2023?
She did.
And did Mr. Maynard send you this particular picture of Ivy's hand?
He did, and I was kind of confused of what he meant by it. She has a callus near her ring finger. She likes to climb, and we actually purchased her gloves for that. But that's a callus. That's not a burn. So I'm not quite sure what he meant by that.
So you're saying that this right here is not a burn from the air fryer that Ivy burned herself on in September of 2023?
No, ma'am. Ivy likes to rock climb. She climbs. We've taken her to so many rock climbing places. We recently purchased her gloves for it because we saw these kind of calluses coming on her skin. It's like the beginning form of a callus, essentially. That's not a burn at all. No, ma'am. So
if Ivy reported that it was, you are saying that's not true?
I'm not sure why she would report that, but it's definitely not true.
Okay. When did you tell Mr. Maynard that Ivy had broken her arm?
When it happened, I believe.
Okay. And did you tell him the circumstances under which it happened?
I can't recall what exactly I stated at the time.
Okay. Your Honor, at this time I move to admit Plaintiff's Exhibit EE into evidence.
No objection.
I'm sorry, what was the exhibit number?
EE. E is an elephant, E is an elephant. Two
Was
E's.
that the picture of the cast?
Yes, in the hand.
All right, and what was your response?
I said no objection, Judge.
All right, so admitted.
On direct examination, you stated that Ivy has a close relationship with your parents, correct?
Yes.
But you have not always had a close relationship with your parents since your divorce, correct?
I can't say since my divorce. My parents are Jehovah's Witnesses. So from the time that I was young, we had differences of outlooks on life, honestly. So from a very young age, teenage age, my mother asked me to leave her home at 17. We have spoken, have tried to, somewhat maintain a relationship, but honestly, that dates back to childhood where my parents just could not accept that I did not want to become a Jehovah's Witness.
You also testified on direct that Mr. Maynard has participated significantly in facilitating a relationship between Ivy and your parents, correct?
Yes, and I've always facilitated that. I've always helped with that, and yeah, absolutely.
You stated on direct that Mr. Maynard has not attended anything at Ivy school, right?
No.
And these events are primarily held during the school day?
No. Her school programs are after school. As a matter of fact, they usually start between 5 and 6. So they're not during the school day, not all of them. As a matter of fact, the daughter dance that Ivy asked her dad to attend was on a Saturday. So no, definitely not always during the school day.
Okay. Mr. Maynard lives over an hour away from Ivy school, right?
Yes, that's my understanding.
Okay. Let's talk a little bit more about the two of your living situations. You stated that at the time of the divorce, Mr. Maynard knew that you were dating Melody, right?
He would have known about both of them. We had conversations about it. He had conversations with my parents. The garden at Lightham confirmed the same thing. He knew what was going on.
And at what point did you tell him that you lived with them?
I can't recall exactly when it happened. Like I said, there were conversations about it, but like I said, I can't recall. I don't know the exact details of it.
Okay. You also testified that you knew that Ivy called Alexa, Mr. Maynard's current wife, mommy, right?
Yes.
And you stated that you did not know that Mr. Maynard and Alexa were married until he testified on direct examination, correct?
Yes, that wasn't something that was told to me.
So you believe that your daughter was calling a woman mommy that her dad was just casually dating?
I didn't know what to believe. I hadn't heard anything from him.
Did you ask him?
I did not, because as we had initially agreed to far before the divorce, I felt like Ivy would be okay until these recent situations with him physically abusing her would be okay in his care. So I didn't have any concerns about it. That was something that we agreed upon. Ivy was safe in my care. She was safe in his care. And the concerns that I had did not start until recently, where she's coming back with bruises and things of that nature.
So she was safe in your care when you lived with Melody and Terence, right? That's what you and Mr. Maynard discussed?
We discussed that she was safe in both of our respective cares, regardless of who's around. We trusted each other's judgment to be able to judge who could be around her.
But that did not include Melody's daughter, that conversation, right?
Melody's daughter wouldn't have been relevant. Melody's daughter was a teenager and lived with her father. She never lived here.
It also did not include T, correct?
It did not. No.
Or her, I'm sorry, go ahead.
No, go ahead.
It also did not include T's son, correct?
No, it did not.
And it did not include that monies would be coming and going to the basement, correct?
The basement wouldn't be relevant. Like I said, it's not connected to the house, so that's definitely not relevant. And even as far as T and, her son, T, Adrian, and I all went to middle school together. He knows T since we were 12 years old. So that's not like it's just a stranger or a complete person around Ivy. We went to middle school together. So this is someone that he knows and was familiar with for sure.
Okay. But at the time that the two of you agreed to your parenting plan, you all discussed Melody and Terence as your dating partners, correct?
I don't know what we discussed specifically. I know that we discussed dating. I know that he knew as far as what was going on. Like I said, there was no sharing directly between the two of us at that point. It just wasn't that type of situation.
So if there was no sharing, then Mr. Maynard could not have known.
He stated to the garden at Lightham that he knew. He stated that he knew from my mother. He stated that he saw Melody come to the pickups. It was known.
But him seeing Melody at the pickups is not the same as you telling him that Melody lives in your home with you and Ivy, correct?
Me seeing Alexa at the pickups wasn't the same as me knowing that he was married to Alexa or that Jaden, a younger, older boy, was in his household either. We didn't discuss those kind of things, and that just was status quo, honestly.
But you testified on direct examination yesterday that you knew about Alexa from the time that Mr. Maynard was in Texas, correct?
No, I knew of Alexa. So when I knew of Alexa, Alexa was last dating or working things out with Jaden's dad. As a matter of fact, one of the outings that Alexa and I had was lingerie shopping for an upcoming visit with Jaden's dad. So as far as I knew, she was still with Jaden's father or working things out. So it was to my surprise to hear of conversations at that time of he and Alexa, saw things online of them posted together while I'm pregnant and we're separated. But ultimately, I did not know any specific details until far after where he and I started having certain conversations.
Alexa is your friend?
So Alexa was a mutual friend of ours. When we lived in Texas, we lived on a military base. One of his commanding officers, I guess, we started going to their home. Alexa she had a child by.
Can you say it again?
I'm sorry, that's Alexa in the back. The Alexa's
Uh.
calling. Give me just a second. But from what I recall, Alexa was dating or had a child by his commanding officer's wife's brother. We would all go over and play games and, have drinks, have food, those kind of things. Alexa and I were friendly and, we spoke, we went shopping. Like I said, one of the times that I can specifically recall was us going lingerie shopping and, finding things for her upcoming visit with Jaden's father. So last I knew, she was with Jaden's father.
But you learned that she was with Adrian while Adrian was still in Texas, correct?
I didn't learn that they were together until Adrian had returned here. He denied it for some time, but I didn't learn anything as far as them being together until he was here.
Okay. You also previously stated that you and Mr. Maynard are currently splitting holidays according to your current parenting plan, correct?
Yes.
You also stated that Mr. Maynard does not celebrate the same holidays as you, correct?
No, as far as to my knowledge from what he was testifying and even what Evie has let me know, she's missing holidays, Thanksgiving and Christmas. She's not celebrating those things anymore.
Evie did celebrate Thanksgiving this year, though, correct?
As far as Evie explained to me, she did not celebrate Thanksgiving.
Okay. So you had no idea that Mr. Maynard and Alexa took Ivy to had a Thanksgiving dinner and the children attended. You did not know that.
No, it's my understanding that Evie did not celebrate Thanksgiving.
So if that's what happened, then it's not true that Ivy is missing holidays when she's with Mr. Maynard, correct?
I guess not, but I guess that means that he didn't provide information not only on the religious exchange, but on her holiday, going-ons as well. So I guess that means that I wasn't aware of him changing from atheist to Muslim, nor him still somewhat practicing Christian holidays during that. So I guess that just means that it wasn't communicated with me.
Okay. You stated that you were consistently afraid of Mr. Maynard threatening you and your family. Is that right?
That's correct.
Okay. But you also testified earlier today and yesterday on direct examination that Mr. Maynard frequented your parents' home specifically to take Ivy there, right?
He did, yes.
Okay. And let's talk a little bit about Evie's activity and Molly. You testified yesterday that you have an issue with Mr. Maynard taking photos of Ivy, correct?
I call them mugshots. I think there's a difference between a smiling, happy photo and her stand here, pose this, let me see this, to display an issue with her clothing, behind her ear, pinky toe. There's a difference between taking pictures and taking pictures for evidence.
The exhibit that I showed you, EE, the photo of Ivy's hand in a cast and what Ivy described as a burn on her hand to Mr. Maynard, you believe that that is a mugshot?
I would describe it as a photo for evidence for sure. From that to the pictures behind the ears to the pictures of the toes, that's not a happy, smiling, say cheese kind of picture. That's a show me your alleged injury so that I can use it.
But he sent it to you, correct?
Yes, and submitted it here as well. Yes, ma'am.
Okay. As it pertains to the modeling that Ivy does, you stated that Mr. Maynard has not agreed to Ivy doing modeling. Is that correct?
He hasn't agreed to her formally modeling. She'll take certain pictures or things, around the house, but he never has agreed to her formally modeling, no, through an agency. That was the point of contention.
But Ivy has done some professional photos, correct?
I'm not sure what you mean by professional. You're saying like through an agency, or what do you mean by professional?
As in, Ivy has modeled for a professional photographer. I'm not specifically referring to an agency.
If you consider Terence a professional photographer, then yes, she's had Terence taking pictures of her. Yes.
Okay. Terence is a photographer, as you just stated, right?
Yes.
You are also a photographer, correct?
No.
You are not a photographer?
No, ma'am.
What is your occupation?
A customer service representative for Siemens Industries.
Okay. So Terence is the only photographer that is taking photos of Ivy, correct?
Yes, when Melody was here, she took some as well, but it's mainly Terence now. Well, it's only Terence now.
And those photos were used for what?
For Ivy to have and to hold. I mean, photographs are to go on the photo albums. We keep them.
Okay.
And it's something that she's always loved to do. She asked to take pictures.
So it is okay to you that Melody and Terence can take post photos of Ivy, but Mr. Maynard may not send you a photo of Ivy's injured hand?
I think that's very different. With Evie asking and wanting to take pictures, she loves to get dressed up and, playing a little makeup and do different things. I think her asking to take fun pictures while doing something that she enjoys is very different when it comes to being asked to show or display something for court and evidence. Let me see behind your ear. Let me see your shoes. Let me see your underwear. Those are very different kind of pictures. I can't compare them at all.
Okay. You're referencing underwear a few different times. 1 second, I'm going to show you. I'm showing you what's been previously marked as plaintiff's exhibit Y. Do you recognize this text thread?
Yes.
Are these your messages to Mr. Maynard? I'm sorry, are these your messages to Mr. Maynard in gray over here?
Yes.
And are these Mr. Maynard's messages to you in blue?
Yes,
And do you recall these messages having occurred on or about Sunday, March 26th of 2023?
I do.
Your Honor, at this time, I move to admit Plaintiff's Exhibit Y into evidence.
Plaintiff's
No,
Y,
No objection.
so
So
admitted.
as recently as March 26th of 2023, Mr. Maynard sent you this message in blue stating that IAB had come over in 2T and 3T underwear, correct?
He sent that message, yes.
Okay. And he asked you what you wanted him to do with them, right?
He did ask me that.
And you said to throw them away.
That's correct. It was something that, like I said, I really try to work for when he mentions these different things just to try to resolve the situation. I had no idea where he was claiming that these underwear are too small came from. Like I said, that's never been an issue. But I just try to keep the peace essentially, and just if that's what is needed, do what you got to do. But try to keep the communication about IFV to a minimum. And if that's what it takes, then just throw them away supposedly, and you enjoy your weekend with IFV.
And you stated that the underwear had never been an issue. Is that correct?
It's never been an issue in my home. No, I can never say it's ever been an issue in my home. I have no idea where it has repeatedly come from. Like I said, from the very beginning, it's been a way to try to create something, find something to be able to present this case, as he stated, since 2018. So it's definitely been to be able to do what he's doing today. I also always ask IFV or follow up when these kind of messages come. Are you uncomfortable? Were there any issues? It's never been a thing that's been said to me.
Okay. So just to make sure I understand you correctly, you do not know where the underwear that your daughter was wearing came from?
I have no idea what he's referring to with that.
Okay. And these were underwear that he did also send you a photo of, correct?
He sent me photos of underwear, but those would have been the underwear that she would have left in. I have no idea where he's gotten those from.
Okay. How many people currently live in your home, Ms. King?
Live will be me, Terence, and Ivy. T is temporarily here on a visit, essentially, but living here would be Terence, Ivy, and I.
And you and Terence are not currently married, correct?
No, we are not.
Are you married to anybody in that home?
I'm not.
Okay. And there are also, did you mention T's son? I'm sorry if I missed that in your last answer.
T's son Elias, yes. I didn't, but T's son Elias is staying as well, visiting.
Okay. And according to your interrogatory responses that we reviewed in V, you've also had at least 2 different addresses, correct?
Since the divorce, I've moved. I was staying at that address during the time of the divorce, and I've since transitioned from there. So yes, I've moved once, as from my understanding, has Mr. Maynard.
Okay. And so not including Terence and Melody, we've just discussed at least 4 additional people who have either come and gone or utilized your home or something of that nature since your divorce from Mr. Maynard, correct?
That wouldn't be correct. Monique stores her things here. T and Elias, that's 3.
T, Elias, Melody. And I'm sorry, is it your testimony that Melody's daughter never came to your home?
Melody's daughter visited. It's her mother, but Melody's daughter never resided here. Melody's daughter resided with her father. Her father had primary custody of Melody's daughter. Melody's daughter never lived here, no ma'am.
But she did come and go from your home, correct?
Come and go isn't the correct word. She visited for a few hours and went back home. Come and go is not a correct term for that. She never stayed, didn't even spend the night, and it wasn't often. She visited once a season, I would say.
Okay. But you recall the guardian ad litem's testimony that Ivy reported to her that she was specifically upset about Melody and her daughter departing, correct?
I recall the guardian saying that, but I can't imagine where her daughter departing would come from. Like I said, we're listening to a 5-year-old at this time. I would think that Evie would understand that if Melody is no longer here, then she may not be able to visit occasionally with her daughter at those times. But even that has been explained. She has access to both of them. So Melody's daughter never lived here.
And even since the guardian ad litem has reported that to you, you have still allowed for Monique to use your basement for her belongings, right?
Monique uses the basement for her belongings, yes.
And for T to come and stay there along with her son, correct?
She's visiting for a time. Yes, her and her son, correct.
And is your testimony that they likely will not be long-term stayers, correct?
T is looking to get back on her feet, so she will not be a long-term stayer. She's, like I said, she's not living here.
And you have allowed this to occur in your home where IIB lives, despite the guardian's testimony and communication to you that a similar situation has hurt IIB before, correct?
I'm not sure how this would be the same. Elias attends IFB school, so IFB would still see them. T and I are friends and have been friends since we were 12, so she would still see them. There isn't going to be any emotional discord behind this because these are friends of ours, almost like family at the end of the day. So this isn't anything that it would be an emotional situation. It's been known that this was temporary, and that's what it was meant to be. T just needed to get on her feet.
And just to confirm, none of the people that we have discussed today were your romantic partners besides Melody and Terence?
Only Melody and Terence. None of them have ever been romantic interests. No, ma'am.
And those are the two people that you and Mr. Maynard discussed at the time of your parenting plan, correct?
We couldn't have. That wasn't the situation at the time of the parenting plan.
So it wasn't the situation at the time of the parenting plan?
You're saying the parenting plan. The parenting plan was established in 2018. We understood and had an understanding as far as Ivy would be in each other's care. We did not discuss the specifics and details of the households. It was not a question either way. But these are recent occurrences. So these were things that were known as far as I understood. Ivy would let us know. Well, he asked about how Zelaya is doing. He asked about how T was doing. It just was what it was.
So all of these are recent occurrences.
Not all of these, no. You're saying T. If you're mentioning T, I can say that that just occurred.
Well, so I'm asking about the entirety of the timeline. And my original question about 3 questions ago was, at the time that you and Mr. Maynard established your current parenting plan, you all discussed Terence and Melody, correct?
Asked and answered, Judge, like 3 times. We went over this at the beginning of the examination and she's repeating it again.
Yes, I'm going to sustain.
I'm sorry, go ahead, Your Honor.
I'm going to sustain the objection.
Okay. No further questions for this witness, Your Honor. Thank you.
All right, redirect.
Ms. King, you were discussing what how you would address Ivy's feet as it relates to any issue that may come up, and I think your response was that you would have provided some topical cream.
Yes, ma'am. If there was any scratches or, small things, I would definitely put a little ointment on it, give her a nice princess Band-Aid, and we keep it pushing.
Okay. I want to show you what was entered into evidence already, as I can't remember exactly what it was labeled, but this was petitioner's exhibit from the first day of hearing. Do you remember this document that I'm showing on the screen? This was the May 22nd, 2022 document that Mr. Maynard testified to when he said that he took Ivy to an urgent care. Do you remember that?
Yes, ma'am.
Okay. And in regards to this document, I think your testimony was that Mr. Maynard would go to urgent care and not Ivy's primary care doctor. Is that correct?
Yes, ma'am.
Okay. So looking at this document, I was able to see down here highlighted where it says treatment. And I saw that the urgent care, the treatment that was recommended looks like a topical cream. You see that there?
Correct. Yes.
Okay. Is that consistent with what you just mentioned, how you would handle anything regarding Ivy's feet?
So that's what I was saying. That cream was a cream that he sent her back with. From there, I think that was Sunday night. So I put it on her the next day. I went to her primary care physician. Her primary care physician advised that it wasn't necessary. So I didn't want to continue giving her unneeded medicine in her system. But so I put it on as it was, prescribed from what I understood. And then when I got a second opinion and it was confirmed not needed, I no longer continued that treatment because it wasn't necessary.
Okay. And are you the parent that takes Ivy to her primary care physician?
Yes, ma'am.
Okay. Did you also take her to her primary care physician earlier this year to be seen? And after you take her to her primary care physician, do you carry out any recommendations or follow any directives of the primary care physician?
Absolutely. If there are any that are given. Absolutely.
Okay. And do you base your decisions as it relates to how you handle Ivy's healthcare? Do you base your decisions off of what you learned from the primary care doctor?
Yes.
I want to show you what has been pre-marked as Respondents Exhibit 46. Respondents Exhibit 46 on your screen.
Yes, I can.
Okay. Is this document related to a March 24, 2023 visit to Greater Atlanta Pediatrics for Ivy's primary care?
It is.
Okay. Did you alter this document in any way from its original form?
I did not.
Okay. And is this document one of the documents that you indicated governed how you handled Ivy's health?
Yes, that was one of a couple of visits that came after the visits that Adrian has referred to that said that there was no fungus, no toe issue, none of that.
Can you pull that over some?
Which way, Judge?
Okay, I'm sorry. I just had to adjust my screen. Go back down again. No, I'm sorry. Yeah, there we go. Right there. No, where the blue, where you highlighted. Did you ever show this medical? This is her primary, right?
Yes, ma'am.
Did you show that to Mr. Maynard?
I assured him of this. I don't think I sent it to him, but I definitely showed it to, I definitely explained that to him verbally for sure.
Okay, you told him that that's what the doctor said. Okay.
Yes.
All right, thank you.
And would you, I moved to tender into evidence Respondents Exhibit 46.
46, so admitted.
Ms. King, would you and Mr. Maynard often, well, let me not use that terminology, however you want to characterize the frequency, but would you and Mr. Maynard have discussions back and forth about Iyavi's feet and, you know, what the healthcare providers are giving you all as far as feedback regarding her feet?
You said, did I explain that to him?
Would y'all have discussions about, so basically Mr. Maynard is presenting one thing to the court and you're presenting another thing to the court. My question is, are you all having that discussion with each other?
Yes, ma'am. I've let him know several times. It's not been reported as an issue by her doctor. There are things that I, do per her doctor, but I've let him know several times. That's not something that her primary care physician has corroborated or, diagnosed her with as well.
There were questions about, you mentioned Iyavi doing rock climbing and when you were questioned about the blisters on her hand. Can you explain to the court the physical activity that Iyavi engages in?
Iyavi does karate. Iyavi does skating, running, biking. Ivy is a very active little girl, so she 100% does all the play things for sure.
Okay. And you mentioned that you took corrective action after you all saw blisters on her hand.
Yeah, so I tried to, continue to ice it and just make sure it wasn't getting too bad. And we purchased her gloves to protect that area of her hands.
Did Mr. Maynard inform you when he was relocating from Texas to Georgia?
No, I was never really officially sure of the time. Sometimes he would pop in, sometimes it would be a visit. I was never really sure of when it was official.
Okay. Do you recall when you learned that he actually moved to Georgia?
I recall it was somewhere Abby was about a year at that point.
Okay. So would that have been maybe somewhere in 2018?
Yes.
And how did you find out that he was living in Georgia in 2018?
It honestly just kind of became an assumption when he started asking for her more frequently. There were some times where he kind of said he's going to be here. I think I recall a conversation where he was saying he's staying with his dad, for a time and, be transitioning onto his own place. But we would meet at his grandmother's or his dad's for visits. And when that became more frequent, I kind of figured it out.
There were questions about Iyavi's daycare, Lifeline Christian Academy daycare.
Mm-hmm.
And there were questions about you obtaining records from them. What efforts did you make to try to obtain Iyavi's record, even for yourself?
I contacted her, I texted, I called, I reached out several times regarding the records. She even also provided him with the paperwork to be able to send it in and get it himself. And she was also called into court, but I did for several weeks try to get the records.
Okay. When you say she was called into court, was there a deposition taken of the daycare director?
That's the word I'm looking for. Yes, ma'am. Deposition.
Okay. And did the daycare director provide my office with any records?
As far as I know, I can't see how she would have because you all would have provided it to me. We have never received any records from the school since she called the cops on Adrian.
And did that play a part in your decision to change daycares for Iyavi?
The environment, at that point with the communication broken, it was clear that kind of wasn't going to be the best place for her. Like I said, I couldn't even get in contact with her. So I did make a different decision at that point. That was definitely a contributing factor.
Have you provided Mr. Maynard or the school or the school access? Or in other words, let me ask it this way. Have you ensured that Mr. Maynard has had access to Iyavi's kindergarten school at Choice, which was her school the first semester, and now her current school?
Yes, both schools. Prior to her attendance at the schools, I provided him with the paperwork so that he could fill out any related information he'd like and be able to get any access as needed. But yes, both of her schools, I definitely did provide beforehand.
There was questions in regards to the exchange location. Particularly, there was a question on cross-examination about the fall break this year and whether you had contacted Mr. Maynard in advance prior to going to the exchange location. Do you and Mr. Maynard typically communicate before meeting at an exchange location?
No, since the parenting plan went into effect in 2018, we never have communicated beforehand. That was kind of the point of the parenting plan, to cut down on any confusion, and we both would be able to read it and interpret it, on our own, be able to come to that conclusion.
You mentioned that Iyavi loves to take photos. Is that correct?
She does. She's always said she wants to be on stage, photos, all of that. So she loves all of that.
Okay. Yesterday, we looked at Respondents Exhibit 12 that was entered into evidence, which was a compilation of photos. Are those some examples of photos that Iyavi posed for?
Yeah, some of those are some of the photos she posed for.
There was questions about Exhibit Y that was entered into evidence. It was a photograph of an underwear that said size 2T and 3T. To be clear, do you know exactly who purchased those underwear?
I don't.
Do you know whether, in fact, outside of Mr. Maynard sending you a picture, do you know whether, in fact, Ivy was wearing those underwear at that particular time when he took the photo and sent it to you?
No. No, she didn't leave with those on.
I have no further questions at this time, Judge.
All right. We're gonna take a 5-minute break and then we'll come back. I think one of you said you had potentially one more witness. Is that right?
Yes, Judge, I do.
All right. Who's that witness?
It's going to be Terence King, Ms. King's partner.
All right, then we'll come back in 5 minutes.
Okay, thank you.
Mhm.
Yes,
Your
Your
Honor,
Honor.
I had a very brief recross of Ms. King.
I'm sorry.
I said I had a very brief recross of Ms. King.
Okay. Okay, go ahead and unmute. All right, go ahead and begin.
Ms. King, as it referred, your attorney recently showed you a visit summary from where you took Ivy to the doctor in March of 2023, correct?
Yes, one of many.
And that was regarding her feet?
That was regarding a second opinion on it. That wasn't for her feet, no ma'am, but that was a second opinion.
The second opinion on the March incident where Ivy had been prescribed the antifungal?
Yes,
And Mr. Maynard took Ivy to the doctor again in May of 2023 regarding her feet, and they prescribed yet another antifungal, correct?
I thought his May was in 2022.
Okay. I'm showing you what's been previously marked as Plaintiff's Exhibit B, that's B as in boy, 2 of them. Do you recognize these messages?
Yes,
Are these messages between you and Mr. Maynard?
yes,
And are these your messages over in gray?
yes,
And are these Mr. Maynard's messages over in blue?
yes,
And do you recognize these messages as a text thread between you and Mr. Maynard in May of 2023?
yes. Well, I can't say May of 20. I don't see a date. I don't see a.
So did you or did you not have this conversation with Mr. Maynard in May of 2023?
You had to show me the date. We've sent several texts over the years. Do you see a date with that?
No, I believe this one only says today when I scroll through here, but I'm asking you if you recall having this conversation in May of 2023.
No, from the last time that I took her, I don't recall him taking her again. So I'm not quite sure.
Okay. But you do recall Mr. Maynard having sent you this message particularly at some point saying that he took Ivy to the doctor and they prescribed her an antifungal.
And I let him know I'd go to get her a follow-up. And that's what I'm saying. I think that was before my follow-up with the doctor, because every time that he's taken her, I get a second opinion with her primary care physician to be sure. And she's always assured me that it's not necessary.
Okay. I'm showing you what's been previously marked as Plaintiff's Exhibit AA. Do you see the date at the top of this document?
I do.
And do you see that date as May 20th of 2023?
Okay.
And do you see that Ivy was the patient at Peachtree Immediate Care on that date?
Yes, I do.
Okay. And do you see the notes here? This is the full document, is that correct?
I do.
Okay. Your Honor, at this time I move to admit Plaintiff's Exhibit AA into evidence.
Okay. But did Ms. King take her to the doctor during this time?
That's
No,
what
Mr.
message. I let him know that I was taking her for a follow-up. So I took her for a follow-up after this. And the doctor
I'm saying, who took her to the doctor, the Peachtree Medical Center?
Mr. Maynard took Ivy to the doctor on May 20th of
So
2020.
this would have been a document he got, right?
Correct. But he and what I previously showed Ms. King was the text messages after that visit, and she stated that she could not recall. So I showed her this exhibit first to refresh her recollection, but I'm moving to admit it into evidence. If the court is not inclined to do so, I can go back to my previous exhibit and ask Ms. King if she now recalls the conversation.
Yeah, you can use double A to refresh her recollection, but not to admit it, because there's no way she can identify this document, and if she wasn't there when they got it. So, but it could refresh her recollection, because you can use any for that purpose.
Understood, Your Honor. Ms. King, in showing you this document that references Ivy's visit to urgent care on May 20th of 2023, and I'm scrolling down here to the bottom where Ivy was prescribed an antifungal cream right here at prescribed. Now, if I go back to what I previously showed you, Plaintiff's Exhibit BB, is this not the conversation that you and Mr. Maynard had following that May visit?
Yes, where I stated that I would take her for a follow-up, which I did, and her doctor assured me that there was no issue.
All right. Your Honor, at this time, I move to admit Plaintiff's Exhibit BB into evidence now that Ms. King has identified the text message thread.
All right,
I
so,
would
I'm
I
No
would
sorry.
further questions, Your Honor.
I would object
An
to
objection?
exhibit AA. The text is, I don't have any issues with, but the actual exhibit, having her to identify and refresh her memory about a text does not serve as a basis to admit a medical document, exhibit AA.
I
No,
think
I'm
she's
moving
just
to
also talking about BB.
Correct.
Oh, okay. I'm sorry then. BB, I don't have any objection to.
Okay. Go ahead.
And that concludes my recross, Your Honor. Thank you.
All right.
Okay. And Mr. King, you are the partner to Ariel King, is that correct?
Yes.
All right. I want to ask you, how did you meet Ms. King?
We met in the Sugarloaf Mall. She was with Evie and her mother, and we was in a proximity inside of a store. I was with Melody. We began chatting and talking, and we exchanged numbers. And basically, that's where we met at and how we met.
Now, I'll just ask you, do you have a criminal past?
Yes, I do.
How old are you?
I'm 46.
Okay. And your criminal past, how long ago was it?
Over 30 years, when I was maybe 16, 17. It was over 30 years when I was 16 or 17 years old.
Okay. And was that for, you had an attempted murder charge and also an aggravated battery charge?
Yes. Mm-hmm.
Okay. How many years did you do in jail?
I served 5 years, and I served 3 years for the other charge.
Okay. So how much time did you actually spend in jail?
8 years.
Okay. And where was that? Where were you living at that time?
I was living in New Orleans, which I was raised and born in.
Okay. At some point you left New Orleans, is that correct?
Yes.
Why is that?
I left New Orleans to kind of consider making a change for myself. City just wasn't right for me. And given the past history of everything that was going on, I always wanted better for myself. And when I was able and capable to do that, I just left to make a better life for myself.
Okay. And are you currently living now in Georgia in the same household as Miss Ariel King?
Yes, I am.
Okay. What do you do for a living?
I do film and photography. I'm an ordained minister. I've been doing that for over 6 years, mentoring kids. I work with 2 programs in Nashville for youth. Try to use my experience of growing up to help other kids not, get in the same situation.
When you say you mentor youth and you have a mentoring program, can you describe what that looks like?
Well, one of the programs is called Stop, Breathe, and Think. And it basically, we work with problem kids or kids that, may have so happen to be incarcerated and come home and don't know how to restart their engine to, get back on the right path. So it's not just about the facility process part, but we also do sports, football, cycling, anything to give them something other than just being bored, which in my opinion leads to the trouble.
How many years have you been working with youth?
I want to say probably 15, 20 years.
Okay. You mentioned how you met Ariel King. You said shopping at the mall. How long have you all been in a relationship? Do you remember that?
I want to say 2018. When we met, we were friends for a very long time. And we kind of sync with, having the same interests and goals and et cetera. And about, I think, 2018, we kind of finalized the real relations.
Okay, so I want to make sure I understand, because you said 2018, you all kind of finalized your relationship. I guess, does that mean you actually started being in one relationship with you, Ms. King, and Melody King?
Yes.
Okay,
And
so
I want to put it like this because I don't want to be misinterpreted. But sometimes you meet people and you're dating, but you kind of don't know which direction you're going. So I'm gonna say 6, 7 months. But for myself personally, I knew that we was going for the long haul.
okay.
Around
You said, sorry.
around 80.
I'm sorry, by the Zoom, it's hard to tell when someone's done talking. Were you done?
Yes, I'm done.
Okay. You said it was 6, 7 months leading up to that. So would that have been in 2017 when you met Miss King?
Yes.
And is it correct you all started living together in 2018? Is that when you started living together?
Yes.
Okay. And when you all were living together, who all was in the household?
Me, Ariel, Evie, and Melody.
What role, if any, do you have in Ivvy's life?
Basically just I assist, do my part with assistant. I can't really consider having a strong role because Ariel is basically home majority of the time. For example, she goes to work on a Tuesday and she gets off at 5. So and Evie gets out of school, like 2:40-ish, around 3 o'clock. So I have like 2 hours to basically assist and help or watch Evie, or we may hit a park or something until she gets off and make it back to the house. Other than that, Air is always fully available.
You mentioned that you may hit a park a time or two. Would you take Ivy to the park?
Yes. Instead of having her just inside, I would check to see if she has homework and if she can start it, until her mother comes home. But if she doesn't have homework, like for example, if it's on a Friday and most Fridays they don't give them homework, then instead of having her cramped inside of the house, I may bring her to a park, which is like we got 2 parks around our house. That's maybe between one is probably only 5 minutes, another is probably 8 minutes.
Okay. Do you force Ivy to call you dad?
No. I was always against that, and not just for Evie, but just kids in general. I feel like it's mandatory that they know who their biological parents are. So I always encouraged her. I remember her making 2 years old, and she started calling me that, and I informed her as much as I could that you have a dad, and I never want to confuse a kid for making them feel like they have 2 dads. And that's just personally me. I don't find nothing wrong with stepdad. And I would hear her even say occasionally, like if we at a park, she says, "Oh, that's my dad over there." And she may say it to the other kids. But do I allow her to call me dad? No.
Okay. So what does she call you?
Terence.
She called you Thomas?
Terence. She calls me by my name, Terence.
Terence, okay.
Yeah. Or she would call me Bishop. Because she's around and some people call me Bishop. So she'll go in between them 2, Bishop or Terence.
Do you force Ivy to not wear socks?
No. When I first heard that, it was, hilarious to me because I'm a sock wearer. Air is not the sock wearer, but I wear socks. So if anything, I would want her to wear socks.
And how long have you been in Ivy's life? How many years?
She's about to make 7. So it's been since she was 6 months. Since she was 6.
You said since she was 6 months old. So would that be since 2017? Sounds like about.
Yes.
Okay. Now I want to ask you, I want you to describe your relationship with Ariel from a standpoint of, do you exercise any control or dominance or coaching over your partner, Ariel King?
No, not at all. Actually, when me and her met, there was a slight age difference, and I really thought that, I didn't really see a relationship, but Air is 5 times mature as her age, and with that, Air has her own mind, her own goals, and her own life. I do feel like a lot of, like, even with our parents, unfortunately, I feel like a lot of people misinterpret the age difference to say that I'm an influence on certain decisions she made. And I have seen that and witnessed that, but I don't believe in control in relationship, even in parenting with kids like that. Even when I'm mentoring kids, I'm helping parents get, back in tune with how to build their relationship with their kids. I don't really believe in influence and manipulation and all, but Areas, she's grown. She makes her own decisions.
Does Ivy know any family members on your side?
Yeah, she knows all of my family members. For that long period of time, since 6 months, she, met my mother, which she calls grandmother. I got cousins, and we have visit New Orleans. She knows all of them. They know all of her. She calls them, FaceTime them or talk to them periodically. She's definitely a part of my side of the family.
Okay.
They would call and send her gifts. They would call her and speak with her. Everybody knows that.
Have you ever met Ivy's father, Adrian Maynard?
No, I haven't, unfortunately. And I kind of feel, a little discomfort there because I am a person that, for me personally, I feel like, and I, acknowledge him being there as a father, but I would rather, him be able to pull up to the house. If I'm the type that if he came to the house and say, hey, where Abby at? Oh, she's up there in her room. You got access to the house. Go ahead and see her. Or I would rather him be able to come and see her, not even through just visitation, court plans. But if there's days that something is done, that he can just come and pull up. Unfortunately, situations have happened. And I also think that he too may feel like I have influence over, some decisions with Air and their relations, but I have nothing to do with their relations. What they have, if it's an agreement, all contrary to each other, I'm in my own lane, but I do support that. That's her dad, she can talk to me about her dad. We actually talk about Adrian, so I'm always encouraged that, regardless of what's going on, regardless how he feels about me personally, but I just feel like we never had that opportunity to get to know one another.
Have you all ever spoken or had any, at least phone conversation or talked at all?
Yes. Recently he called. I'm not sure what it was about, but he called. I was in here. Him and Air were talking, and I hear him a lot sometimes, and he's cursing her out, profanity, all of this, and I, emotional behind what's going on. But out of all of the years, this was recently, I want to say 3-4 months ago, he called, and then he started calling names and like call him and, the N-words and all of this or whatever. So I, took the initiative to call him. And even then, from what I was hearing, how he was addressing me, he, was still kind of respectful. So we tried to have a dialogue, and it still didn't work. He felt like, I was accused of not, I guess, being a good guy because I never introduced myself to him. And that was basically it. And even then, the conversation ended with him, having the same tantrums, going off, the name call and, old ATIS and that. And I was just like done with it, I'm about solutions. So once I saw that it wasn't becoming of a solution, I even offered to meet with him. But it seems to me that, certain people want to just meet out of anger versus meet to talk. So I felt like, meeting to talk is one thing, but out of anger and all of that is, but the whole thing is just an unfortunate situation to me. But that was the only time that I have spoken with him.
Okay. And that was going to be my follow-up question. So that was the 3 to 4 months ago, that phone call was the first time and the only time that you and Mr. Maynard have spoken?
Yes.
Okay. I think you've already mentioned this in your testimony, but I just want to be clear. Would you continue to be supportive of Ivy maintaining a relationship with her father, Mr. Adrian Maynard?
Of course, definitely. I mean, it's like, it's a father thing. It's fatherhood. I'm a father myself. And I have a daughter. In fact, my daughter's a lawyer I raised. So I know what it feels like. And that's why from day one, I always encouraged it. I never was against it. I encouraged it. When she would call me dad, I know how it would feel if my daughter called someone else dad. So therefore, it's personally, I just can't take certain grounds that people take or stances that people take outside of encouraging fatherhood or encouraging a daughter or a son to know who their biological father or mother is and to want them to be a part of their lives.
Okay, thank you. I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Mr. King, you stated that you've never met Mr. Maynard. Is that correct?
In person? Yes, that's correct.
But you did meet Mr. Maynard in August of 2019, the day that he and Ms. King were arrested, correct?
No. When I got there, they was already in the back of the police car pulling off.
So you did not take Ivy and take her inside the house on that day?
It was at the gas station. It was in a resident area. I had to get there because both of them was getting arrested. So by the time I got there, the situation was already ending, and Evie was able to give me access to be able to get Evie because both of them was going to jail.
And on that same day, the police asked you for your name, correct?
Mm-hmm.
And you did not provide them with your name as you just provided to the court, correct?
No, I had a cousin with me, and I used my cousin.
You told the police your cousin's name when they asked you for your name, correct?
No, the police dealt with my cousin. I didn't want to be affiliated at all with my name involved. My whole goal from the beginning of understanding the dynamics which was happening with him and her, I never wanted to be involved because it was just too out of hand. I wanted to stay in my own lane and mind my business.
Okay, so I just asked you, did the police ask you for your name on that date? And you said yes. I am asking you now, how did you answer them? What name did you provide to the police when they asked you, what is your name on the date of that incident?
Terence King.
You told the police your actual name on that day?
Yes.
And you did not tell them your cousin's name. Is that correct?
No, my cousin was with me. So I let my cousin get her.
But you just told me you got her when you got there.
As far as pulling off, yes. Pulling off with Evie, having Evie, yes.
Okay. On direct examination, you were asked about your criminal record, right?
Yes.
And you stated that you had been convicted of aggravated assault and battery over 30 years ago, correct?
Mm-hmm.
But you were also charged with 2 counts of murder in the first 27 years ago, correct?
I can't really pinpoint back to the actual date.
In 1996, you were charged with 2 counts of first-degree murder in Louisiana, correct?
Yes. Mm-hmm.
But you did not answer Attorney Fowry when she asked you about your criminal record. You did not say that you had been charged with 2 counts of first-degree murder in 1996, correct?
No, I think she specifically asked me about 2 charges, and that's what I answered to, not to what you're speaking of. There were a lot of cases. I've been started at 14 or 15 years old of having cases and going back and forth to jail. So, go ahead.
Did you serve prison time for the 2 first-degree murder charges in 1996?
Yes.
How long?
5 years.
You served 5 years for 2 counts of first-degree murder?
Yes. Yes.
Or did you serve 5 years for the aggravated assault and battery that Attorney Fowry just asked you about?
Battery was 3 years.
Okay, so how many years did you serve for the 2 counts of first-degree murder?
5 years. A total of 8 years, both together.
Okay. And as it pertains to your current status, are you currently on probation or parole?
No, ma'am.
Okay. And you have not disclosed the full extent of your criminal history to Ms. King, correct?
No. I mean, in bypassing, she knows of me having a record. She knows of me had done time, but not just specifically details or specifics of case.
And you and Ms. King have been in a relationship since 2018, right?
Yes.
Okay. No further questions for this witness, Your Honor. Thank you.
So, Mr. King, did you ever tell her that you were convicted of 2 counts of first-degree murder?
No, I haven't told her that I was convicted. I have said, the confusing part is I have said that I've been to jail for murder, but it's just like, even me now, after 27 or 30 years being so long ago, it's hard for me to recollect what the charges was broke down to. Like even, like for example, the murder charge that I went on in 96 was a first-degree murder. So when I got the time for it, then it became second-degree murder. The time that I did 3 years on the aggravated battery, like for myself, if I was talking to my mother, I would say the attempt murder, because when I went in, they said attempt murder. However, it was below the waist, so it wasn't an attempt murder. So when I got the time, it turned to aggravated assault versus attempt murder. So,
So you served time for 1 murder or 2 murders?
1 murder and an attempt murder.
Did 2 people die?
No. And mind you, I want to say this, like, it's not, my situation was self-defense, and that's why I wanted to leave the state. The person had a gun and I protected myself.
Okay, I don't need to go into the background. I'm just trying to figure out what you told King.
Yeah, 1 person, and the other one was attempt murder.
Okay, but she was aware that you were in prison or you had done time for murder, is what I'm asking.
I can't say that. I can't say,
the
because
first time hearing that is today?
No, I was, if she heard it, it was probably in passing. If I was discussing it with somebody, or sometimes she accompanies me when I'm mentoring and stuff like that, or I'm out speaking and I may speak about these things, but not, I can't say we personally ever had a conversation literally like, hey, I was a murder charge or attempt murder. It's more like, hey, I did time and that's it. We never really discussed anything big or gigantic of the matter of the case, other than I did time in jail.
All right, thank you. Any additional questions?
Yes, Judge. Do you know, Mr. King, whether or not Ms. King was aware that none of your, excuse me, were you aware, or do you know whether or not your partner, Ms. King, knew that none of your charges involved minors?
Yeah, that was something we talked about. I was questioned about that. In fact, now that I'm thinking back, her parents asked to meet me when we first met and we was getting close. And I met with her mother, and her mother had a list of questions that I said. Her dad never showed, but her mother and I sat down and she asked me a list of questions. And I actually told her mother my background and, you know, troublesomes. And we had a genuine conversation, an open conversation. And that was at Air's home when Air was living in her place. But I just know her mother indicated molestation and all of that. And I remember saying bluntly, yeah, I don't have anything like that on my record. But that was a concern of her mother's, and Air was present at the time when we discussed that.
Okay, so when there was the list of questions from her mom regarding your background, you said that discussion took place in the presence of you, her mom, as well as Ariel King?
Yes, me, Miss King, and her mother.
Okay, so when you were meeting with her parents, presumably to discuss your relationship with Miss Ariel King, you all did get into your past?
Yes, her mother had, I mean, and I respect it, you know, and I respect her mother hugely because she asked all of the questions that she wanted to ask. And I felt, you know, accountable to answer because of the age difference. And I wanted her to know her daughter was secure. There was no manipulated type of situation or influence, that Air has her own mind. This is something, you know, she wants, and if she changes her mind, she can. but she had a role. We talked for maybe 2 hours.
Bless you.
Bless you.
Okay, thank you, Mr. King. No further questions.
All right, any additional witnesses?
Oh, I'm sorry. What was that, Judge?
Any additional witnesses?
No, Your Honor.
All right, so
The guardian ad litem, Your Honor, the plaintiff would like to call the guardian.
I'm sorry.
The plaintiff would like to recall the guardian ad litem, Tory White.
Okay, how much time do you think you need for that recall?
That's a question for Ms. Kreitz.
Huh?
That is a question for Ms. Kreitz, who will be conducting that examination.
Okay.
Your Honor, I don't anticipate more than an hour, but it is 12:30, and I imagine Your Honor would probably like to eat, so it's up to you.
Okay, I have another matter that I'm trying to grab as well, so I'm gonna ask you all to come back at 1:10.
Sure.
All right, thank you. Ms. Marshall indicated there's another witness, and I did not take that into consideration because I have another trial that I was about to try to start today. So, can you give me a understanding who the other witness is and the time frame that you were considering for this other witness?
Yes, of course, Your Honor. I just need 5 minutes with this witness. It is the briefest of brief rebuttal witnesses.
And Judge, I was not aware of any other witness either. Specifically, this witness was not disclosed in discovery. There's never been a discussion about this witness. Even with supplementation responses and discovery and interrogatories that were exchanged, there was no indication that this would be a potential witness. So I would object just because this is, for me, is trial by ambush. I haven't had an opportunity to even explore any allegations or what this witness intends to testify to.
Yeah, of course, Your Honor.
What's the rebuttal?
Sure. We wouldn't need a rebuttal witness to Mr. King's testimony had he not blatantly lied on multiple counts about interactions with Ms. King's parents. So this rebuttal witness is to rebut Mr. King's testimony. Therefore, we could not have possibly disclosed in discovery because we would have not known that Mr. King would have lied as much as he did on his direct and cross-examination.
There was no mention. Oh, I'm sorry. Go ahead.
Also, you don't have to disclose rebuttal witnesses in discovery. The purpose of a rebuttal witness is just that, to rebut during trial.
And that's not the case, Judge, especially when you're specifically asked to identify those witnesses that may be potentially called to trial. Mr. King never mentioned an auto ham. Mr. King actually testified as it relates to Miss Ariel King's mother. So in regards to any rebuttal, certainly that would be inappropriate. And like I said, there was no identification of this particular witness.
Okay, so one, I think Ms. Kreitz is right. You don't need to necessarily identify a rebuttal witness, but that, it means that something came up that was not foreseen. And generally, you could have rebuttal witnesses in that light. I am, however, concerned about the necessity for the witness and where we are because I don't know if I necessarily think that whether he met with her mom or dad is of relevance to the case, to be honest with you. However, and I think secondly, I think he indicated that he did not meet with her dad, that he only met with her mother. And so if Mr. Ham wasn't there, I don't know how much more information he could give on the issue. But more importantly, I just don't know the value of it. But you said it's a brief witness. So I'll let you start, but if I feel like it's not adding anything, I'm gonna stop you.
Sure.
So we're gonna go ahead and get started with your with the guardian ad litem. I know you asked for an hour. I'm just kind of at a loss as to how much more. I don't know how we can another hour. I can't fathom another hour. You've already kind of exhausted so many issues, and I just don't see how. I can't imagine a full hour. So I'm going to tell you these questions better be tight because if they're not, I'm stopping you.
Your
And
Honor,
Judge, I'll say, I know we've had multiple court appearances, but Ms. White was the very first witness on day one, and then the court excused her. And so we went to day two with a full examination of Mr. Maynard, and I crossed him. Ms. White was not present there. And then she appeared yesterday, of course, but I was surprised that they were calling her back too, because she had been excused on day one and did not appear at trial on day two when further evidence and testimony came out.
So,
Okay.
Your Honor, two things. One, I always, lawyer time, judges like to make fun of that. So I do try to overestimate how much time I will need for consideration of the court's time. So I do not actually anticipate I would need the full hour. And two, as I stated yesterday when we gave our time announcement, it is extremely prejudicial to us who the last time we were heard and when we arrested was in May. And the other side got to present evidence for instances that occurred between May and now, which the guardian ad litem did investigate. So it is prejudicial to us to not get to present evidence during the same time frame when we had rested our case afterwards, which is why we are recalling the guardian.
Okay, you may proceed.
All right, so first I'm going to very quickly call Otto Ham to just so I can excuse him. All right, Mr. Ham, how are you related to the parties?
Ariel is my daughter.
Okay. Mr. Ham,
Evie is my granddaughter.
thank you. Have you ever met Terence King?
I met him twice. The first time I met
Go ahead.
the first time I met him at the apartment that we were helping Ariel with, and that was the apartment that they were just a few minutes from us. We were helping her. The second time I met him was at Ariel's grandmother's house, and at that time, the day before, a couple of days before, he had an argument with my wife in front of her mom. He was arguing and so on and so forth. The time that I met him afterwards, I was sitting down, he came in and he approached me and started talking back and forth, and he was telling me how he was going to break my jaw and how I need to come outside. He kept coming back and forth to the door, very violent, once he closed the door and left, he came back at least 3 or 4 times, kept saying, follow me, I'm going to break your jaw, I'm going to do this and I'm going to do that. Very, very aggressive. I was not so much concerned for myself, but I did not like the way that he showed out in front of Anissa's mom, in front of
wait, Mr. Ham, who is Anissa?
Anissa is my wife. He was arguing. So we're at Anissa's, my wife's mother's house.
Mr. Ham, hold on. Let's get the breakdown. What prompted the fight between you and Mr. King?
I don't know. I mean, I'll say this. Before he was talking to my wife the day before, I was sitting on the chair when he walked into my mother-in-law's house. He walked around her and started asking me, what are you looking at? And like, what? He goes, what are you looking at? And he goes, kept approaching me in that way. What am I looking at and so forth? And then he started saying things like, I'll break your jaw. You come out here, I'll break your jaw. And I'm like, what? And so at this point, I'm getting up and my mother-in-law and my wife is telling me, no, don't go out there. Don't go out there. My granddaughter is there crying as he's constantly egging me on to try to, fight with me. But that was my second time meeting him. And when I met him at that time and I saw how violent and how just over nothing, I don't know, me sitting there, how violent he was, I said, this is not for my daughter, but she didn't want to listen to me. She felt like I didn't know him, but he's already had a conflict with my mother-in-law in her house. He had a conflict with my wife at my mother-in-law's house. And he also showed great disrespect to my granddaughter. I'm trying to charge my phone, but that's how I knew him. When I tried to talk to my daughter about him, she basically told me I didn't know him. I explained to her, I know just how they came together. And I tried to tell her how violent he was, but she did not want to listen.
Okay. Did you ever discuss Mr. King's criminal history with Mr. King?
No, like I said, I only talked to him during that time. That was the time when he was really violent towards the family.
Do you know Mr. King's criminal history?
Do I know it? Yeah.
How did you come to know it?
Well, to be quite honest, when I heard it from someone, but then we had someone look into it.
Hold on. Let me just ask you this. Did you hear it from your daughter?
No, absolutely not.
Did you hear it from Mr. King?
Absolutely not.
Did you hear it from your wife?
I think when we had an investigator or something like that, the investigator came up and they were telling us about him. When I tried to tell my daughter, she basically said, don't tell me anything. If she didn't want to hear anything that I had to say about him. Now, some say that we had a problem with her, but our problem was, first of all, he was way older than her. The next thing, how he reacted around, just showed great disrespect to Anissa's mother or Ariel's grandmother. She showed great disrespect to me the second time I ever met him. And then she showed great disrespect to our granddaughter. And I saw how violent he kept coming back to the door, knocking on the door, telling me to come outside. He's going to break my jaw. He wants to fight. And I tried to tell Ariel this, but she did not want to hear it. Okay. So the reason that I'm talking now is because I have no ill will towards my daughter. She is 30 now, and I have to realize that she is an adult. However, I am very concerned about this guy. Now, this wasn't too long ago when all this happened. I am very concerned about how quick and how angry he got and how things got so out of control so quick by me sitting there and looking. And like I said, I don't know him. I just know from what we researched and how personally my second time communicating with him, how violent he is.
Okay. Do you have any concerns about Mr. King being around your granddaughter?
Very much so. Like I said, if I never saw how violent he was at my mother-in-law house, and how he kept coming back and knocking on the door and trying to get me to come outside, he wants to fight, he wants to break my jaw, he's going to do this to me, he's going to do that to me. If I didn't see that, and she would be right, I didn't know much about him except that to me, he preys on younger girls. However, in seeing him react like that, and he didn't care who was around, seeing him act that way was very concerning for me and very concerning for my grandchild.
Do you see your grandchild regularly?
If I see my grandchild, I have to go down to my ex-son-in-law's house. I can say, maybe pre-pandemic. Let's see. I don't want to. There's been times where my wife had picked her up and I saw her, but as far as having a regular communication or having a chance to see my granddaughter like at our house, that doesn't really happen that often. I say often, that really doesn't happen. As a matter of fact, we can't see her on video. Even if we Zoom her, she can't have her video on. And basically thinking that for some reason that we would want to take pictures or something. But we, even on Zoom, if she Zoom us, she did Zoom us and she's allowed to Zoom us, but we can't see her by means of the camera. So
when she's with who? Mr. Maynard or Miss King?
When she's with Ariel, I don't recognize her as Miss King. I'm sorry. He's married, as far as I'm concerned, to Melody, and I don't recognize her as Miss King. That's her name. I understand she's adult, but that's just me. I respect that that's what they want to do. That's what she wants to name herself. That's fine, but I don't recognize her as Miss King. She's Ariel.
All right. Have you ever known Mr. Maynard to be violent towards Ariel?
No, I haven't seen it. I've heard Ariel tell her mom that. I haven't seen it. I just haven't seen it. Now, have I heard that they argued before? Yes. Have I heard that he laid his hands on her? Well, no, but I take this back. I did hear when they had that they were doing a drop off, that they were arguing and both of them had gone to jail because they were arguing. And I don't know who hit who, or I heard that they were both. I don't know. I wasn't there, so it would be hearsay. But I will tell you that if I had to say, I would say yes. As adults, they probably have argued. Have I ever seen anything physical? No. The only thing that I heard about was physical was when they were dropping at the halfway mark, and some cops were called. That's what I heard.
Have you ever known Mr. Maynard to be violent towards your granddaughter?
I've never seen that. When we've gone over there, I've never seen that he has been violent towards her. I've never seen that.
I have no further questions for this witness. Thank you, Mr. Ham.
No problem.
Mr. Ham, do you live in Georgia?
I sure do.
Okay. You've known Adrian Maynard since he had been married to your daughter, Ariel, correct?
Yep. Yep.
Okay. And let me just back up. You said you don't recognize your daughter as Ariel King. When you say you don't recognize her as Ariel King, are you saying that you refuse to mention that her last name is King?
Well, the thing is, they're not married. But I didn't want to get into that. They're not married. Terence is married. I had a problem with Ariel getting involved in their marriage. I said, leave that alone. You're young. You don't have to get involved with that stuff. So my thing is, you're married. No other individuals need to be inside of that marriage. That's a sacred vow that God has ordained. So I don't agree that if you're married, you should have other mistresses and another wife and all that stuff. I believe that, which is really outside the thing, but I just feel like they're not married. She takes on his last name. That's their thing. But I'm just saying Ariel. And if she doesn't want to say Ariel Ham, that's fine. I just says Ariel. And this is really outside of what we're talking about. It's just, I just say Ariel.
Okay, well, I'm just following up on your comment to the court. So do you realize that your daughter legally is named Ariel King? Did you know that?
I didn't know that till a while back. But again, that's her choice. She's an adult. She's an adult, and if she wants to change her name, that's fine. But are they legally married? I just found out today that they were not legally married. But if she wants to change her name, then she has the right to do that. So I said, okay, I'll recognize that her name is now Ariel King. If that continues to move us along. Sorry.
Okay, so you've been aware that your daughter had been in a relationship with 2 other individuals. You were aware of that, correct? That's what you're disapproving of?
Which 2 other individuals? Terence and his wife?
So you mentioned that you don't believe that relationships or marriages should include multiple people, correct?
I believe that if a husband and a wife are married, they don't have to have, at this time, she was fairly young, someone that's almost 17 years younger than him to come in and play games with. I mean, you can get into this if you like, but Ariel, we would have preferred her not to get involved with Terence and Melanie's marriage.
Okay, Mr. Ham, let me ask you this. Did you know that Adrian talked to your daughter about having an open marriage and dating other people when they were married? Did you know that?
So again,
yes or no? Did you know that? Yes or no? So I understand what your answer is. Did you know that Adrian Maynard, your ex-son-in-law, talked to your daughter when they were legally married about dating other people during their marriage? Did you know that?
I'm finding this out through the videos, through this conferences now. I'm finding this stuff out through the court case. Before the court case, no. I'm finding this stuff out by listening to what's going on in the court. That's the best way I can answer. So if you ask me, did I know that when Ariel was in El Paso, I think, I did not know what was going on in El Paso. I did not find out what's going on and hearing about all this stuff until I'm listening to these hearings.
When you say you're listening to these hearings, did you hear or watch any proceedings prior to today?
Yes, these hearings, that means this one and whatever other little hearing, I've been picking up on stuff when I'm able to. So I'm finding out and hearing things. She didn't tell, if you ask me, did she tell me personally that that they were having open marriages or whatever, or I'm finding that stuff out as I'm listening to what's going on.
So you've been listening to this custody trial during other appearances that have taken place in this case?
When like now I'm at work, but I just wanted to
answer my question, Mr. Ham. I'm not asking about where you are. Mr. Ham, only one of us can talk. Listen to my question and I'll let you answer. My question is, you mentioned you've been learning as these hearings go along or something to that effect. So what I'm trying to understand is what you're referring to. Have you or have you not been listening to these court appearances involving custody of your granddaughter?
I'm going to object. That's been asked and answered. He already answered that he is good.
I've been listening to
1 second. I don't think he has. Even I'm confused. So I want him to answer.
Okay, so I have been listening to the hearings, and when I have been listening to the hearings, that means what we're doing now and earlier when I'm able to. If I listen in, I'm hearing this type of stuff. I don't know if that's not clear that I'm listening to the hearing, but I'm not sitting here like 8 hours because I do work. But I am hearing that stuff. And if you ask me, have I heard that through the hearings? I would say yes. As I'm listening to the hearings, I'm hearing about what's going on, but I had no pre-knowledge of that, if you understand what I'm saying. I hope you do.
I understand exactly what you're saying. So basically you have been hearing witnesses testify in this case, correct?
Yes.
Okay. So you mentioned El Paso, Texas. Your daughter lived in El Paso, Texas with Adrian Maynard, right?
Yes.
And do you remember when you had to purchase a flight ticket, fly to Texas and rescue your daughter after Mr. Maynard was beating on her? Do you remember when you had to go do that, Mr. Ham?
Okay, let me say this again.
Yes or no? Do you remember?
I remember purchasing a flight.
Do you remember that the reason you hopped on that flight to go to Texas was to bring your daughter back from Texas to Georgia? Do you remember that?
I remember bringing my daughter back from Texas to Georgia.
And do you remember that the reason you had to bring your daughter back from Texas to Georgia was because Adrian Maynard raised his hand to hit her? You remember that?
Honestly, no.
Okay.
I didn't know why I knew that they were having marital problems, but I did not know that violence was involved.
So
That's what I'm sorry.
No, go ahead. I didn't mean to interrupt.
No, I'm just saying, I know that they were having marital problems. I did know that. Her mom was going to come down there and pick her up. Her mom was going to fly. I said, and then they were going to drive back. I said, no, if you're determined for her to come back, I will go there and I will drive her back. But did I know violence was involved? No, I never knew that violence was involved.
So when you arrived to pick up your daughter, because the question was asked of you and on direct examination, have you recognized Mr. Maynard be violent towards Ariel? When you went to go pick up your daughter in Texas, when you arrived, you saw that the bathroom door was broken, right?
I didn't. No, I did not notice that.
And yes or no, did your daughter not reach out to you about domestic violence that was occurring at the hands of Mr. Maynard when you went to go pick her up? Did she not reach out to you about that?
I just said I did not know about violence. I'm not sure.
Listen to my question. Not that did your daughter reach out to you and tell you the violence that was occurring in that household when you went to go pick her up in Texas?
I'm going to object to this as asked and answered. It has been asked 3 different ways. I asked on direct and she asked on cross, now twice. He has no knowledge of violence.
I'm sorry, 1 second. The question is, Mr. Ham, is not what you saw or what you witnessed. The question is, did Ms. King ever tell you?
I do not recall anything about violence. I'm sorry. I do know that they were. I didn't know anything about violence.
Okay.
I know they were having marital problems, but I did not know about violence.
Okay.
And you said you knew about the incident in August of 2019 when both your daughter and Mr. Maynard were arrested, right?
I heard about. I wasn't there, but I heard about it. Yes.
Okay. And one of the things you testified about your involvement with your granddaughter. Is that Ivy that you're referring to when you say my granddaughter?
That's my granddaughter, my only one.
Okay. When's the last time you said you saw Ivy?
I know my wife had picked her up. I don't know the exact time, but it was maybe a few months back. My wife had picked her up and she came here. But as far as before that, we usually would ride to, I can't think of the name of the place right now.
So my question was in the form of a time. Okay.
I'm sorry.
So maybe, I asked you, when was the last time that you saw Ivy? Was it in 2023?
Yes. Sorry. Yes. 2023.
Okay. So you said that there was an incident. So let me make sure I understand your testimony. You said that you had 2 encounters with Terence King, right?
Yeah, I had.
Okay.
Okay.
I didn't ask you anything else. Let me explore that. The first time you said the first encounter you had with Terence King was when Ariel had an apartment. Was that your testimony?
That's when we had it. Yes.
Okay. Was that during the time that Ariel was married to Adrian Maynard?
Was she married? Ariel, I'm going to ask her, when she left and came here, it wasn't long after. She stayed with us for a while, then she got an apartment. I don't know if they were still married or not at that point. I know that they were going to have divorce proceedings. I'm not sure if they were married at that point or not.
When you picked your daughter up from Texas, where did you take her when you brought her back to Georgia? Where did she go?
To my house.
To your home?
Yes.
And when she left your home, she got an apartment?
She was down the street from us, and we were helping her with the child and daycare and so on and so forth. Yes. She was maybe 5 minutes away from us. Yes.
Okay, that was the apartment that you're describing, correct?
Yes, that's the apartment that I saw him at.
Okay, so when you saw him at that apartment, did you have any interactions with Mr. Terence King at that time when you saw him years ago at the apartment that she was moving into?
When I saw him at that apartment, we walked in. I think, if I remember correctly, he was doing something on the wall. He looked at me and I was looking at him, and I don't even think he spoke. And I don't think I spoke because I didn't know who he was. And obviously he wasn't interested in speaking to me.
Were you in fear on that day of Mr. Terence King when you saw him?
Say it again?
Were you in fear of Mr. Terence King, that first interaction you had with him?
Was I in fear? He didn't speak. I didn't speak. I wasn't in fear of him.
Okay. Second interaction you said you had with him. You said that was when Terence King went to your daughter's grandmother house, correct? It was your daughter's grandmother, correct?
Well, yeah, my wife's mother, yes.
Okay. So you mentioned that during that time that Terence King threatened you with talking about he was gonna break your neck or do some physical harm to you?
Yeah, he's gonna break my jaw. Again, he had a night or two before, he was arguing with my wife at her mother's house. And my wife was telling me something, but I didn't hear.
Hold on, Mr. Ham, were you present the night before? Were you present the night before?
I was not.
Okay, so I'm asking you about when you said you were present. So the day that you, listen to my question, the day that you said that you were present, you said that Mr. Terence King threatened to break your jaw. Those are the words he said to you?
Yeah, the exact words. I'm gonna break your jaw. Yeah, those are the exact words.
And so after he said that to you, you surely called the police to report that, right?
I actually did not call the police. Maybe I should have called the police, but he was walking away trying to get me to come outside to a park or something. Come out here, come out here. He came back and forth to the door 3 times. And that's how it happened.
Well, surely you called your daughter and told her that he threatened to break your jaw, right? You told your daughter that.
Again, yes. Again, I tried to tell my daughter about it, and she did not want to hear it. I don't want to hear it. I don't want to hear it. She took his word for it. I don't want to hear what you have to say. I don't want to hear what you have to say. You made him mad. You made him mad. I don't want to hear what you have to say.
So Mr. Ham, you're saying that an adult man said that he was going to break your jaw, and you told your daughter, and you're saying your daughter said she didn't want to hear about it. That's your sworn testimony?
That's my sworn testimony. I kept trying to tell her. She kept telling me, I don't want to hear it. I don't want to hear it.
Well, how long ago did this happen?
This would have happened. I should have wrote down the date, but this should have happened. Maybe 6 months, maybe 8 months. I didn't write down the date. I'm sorry, I don't have the exact date.
6 to 8 months ago?
You're asking me a question. I'm just trying to give you the answer.
You said 6 to 8 months.
I'm giving you a guesstimation, and since that time, I haven't seen him. We don't talk. They don't talk to us.
Listen to my question, Mr. Ham, because you're wanting to get into more details that I'm asking, and it's very confusing what you're trying to tell this court. What I'm trying to understand is when are you saying this incident happened? Because if somebody threatened to break my jaw, I would certainly remember when it happened. So when did this occur?
I'm going to again say maybe about 6 months ago. And I'll stop there since you don't want me to say anything else. And on or about June of 2023, you're saying this is when Mr. Terence King threatened to break your jaw? I guess that's what's around that time.
So when this happened, you contacted Adrian Maynard and told Adrian Maynard about it?
Did you just add that into it?
I'm asking you, did you contact Adrian Maynard and tell him about it when it happened, when you say it happened? Did you contact your ex-son-in-law and call him and tell him that Terence King threatened to break your jaw?
I didn't particularly call him that day, but I do remember we going down and we were talking and what have you. And that question, and that came up about, it did come up. But did I call him that day or what have you? I don't know if that was the case. Just like I didn't call the cops. I didn't want to have the guy arrested. I didn't have him arrested or anything like that. He left. I went back. We sat down, and I haven't seen him since then. I haven't talked to him. I really haven't spoke with Ariel.
I'm asking you about Adrian Maynard.
So I just said that I did not call Adrian at that time, that day or hour or whatever that I can remember, and says, hey, this guy said that he was going to break my jaw. I don't remember calling Adrian that day or whatever and saying that.
Okay, so when you did talk to Mr. Maynard, it was sometime after that. Is that correct?
I don't think I would have talked to him before, so I'm going to go with a yes. I think I talked to him after that accusation, or after he threatened me. I'm going to go with a yes.
Okay, after you told Mr.
Not an accusation. I'm saying that I would have spoken with him after it. I wouldn't have said something like that before it happened. So you asked me, did I speak with him afterwards, after it happens? The answer is yes. I spoke to him after it happened.
So what did Mr. Maynard tell you, or what did y'all discuss after you told Mr. Maynard that Terence King threatened to break your jaw? What did he say?
I don't recall. What did he say 6 months ago or so when I told, or whenever it was that I told him. I don't recall what he said. Probably shocked and surprised. I mean,
So you don't remember what you all discussed when you told him that Terence King threatened to break your jaw?
probably very shocked and surprised. I can't believe that happened. I can't believe that happened. I mean, I can't believe he threatened you right there in front of your mother-in-law and your wife and your grandchild. So yeah, it was a discussion.
So this incident that you said happened, was Ariel's grandmother present?
Of course. It was at her house. She was standing right there in the doorway telling me not to go out there and fight him, not to go out there and fight him. So was my wife out there, and Eddie was right here, right beside me.
Okay. Well, Mr. Ham, did you know that just about 3 weeks ago for Thanksgiving, that Ariel's grandmother that you said was present, Ariel, your granddaughter, Ivy, and Terence King went to see a movie together at the movie theater? Did you know they just did that 3 weeks ago?
I do.
You say you know that?
Yeah. What's your point?
And so do you also know that your wife has been to Ivy's school this semester? Did you know that?
I know all of that probably happened perhaps within the last maybe 3 weeks, that they just started coming around.
No, that's not what I asked you. I'm asking you, did you know that your wife went to the school this school year?
Yes, ma'am, I do.
Okay.
Yes, ma'am.
And just to be clear, you don't know well, scratch that. Let me ask it this way. You mentioned your wife's mother, so Ariel's grandmother or Ivy's great grandmother. You mentioned that she was present. She didn't contact any police or law enforcement, right?
Listen, I'm sorry, ma'am.
Yes or no? Did she contact the law enforcement or police?
I'm going to object. He lacks personal knowledge as to what she did.
I asked him, does he know whether she did it? He was present.
I think I've heard enough of this line of questioning.
Let me see. Let me double check my notes, Your Honor. Mr. Ham, you testified that this incident occurred 6 months ago. Did you mean it occurred 6 months ago? Or are you trying to say it was when Ivy was 6 months old?
No. I said 6 months to 8 months. It could have possibly been a year. This is not something that, I was trying to remember or something that I want to bring up. My concern, obviously, in bringing this up was just that I was concerned about how his attitude was, and I was concerned for my family, and I was concerned for Evie. I tried to explain to Ariel that this guy was violent. She didn't want to hear. This was just an opportunity for me to say, this is what I've experienced. This is what I've experienced with him. I'm not holding on to animosity trying to call the cops, but it was just a needed conversation to say how aggressive this guy was and how he kept coming back, banging on the door, trying to get me to go out and fight. That's all.
Mr. Ham, at the end of the day, you just don't like the fact that your daughter is in a relationship with Terence King. Is that correct?
Okay.
Is that correct? Yes or no?
I don't like him. I don't like his attitude. I don't like his violence. I don't like the way that he treats my family, her mother, my wife, the granddaughter, and even Ariel, but Ariel doesn't want to hear it. So if you ask me, do I care for him? Absolutely not. Am I concerned about my daughter's welfare, my granddaughter's welfare, my wife and my mother-in-law welfare? Yes. This guy appears to be very violent. He kept coming back aggressively trying to fight, wanting to break my jaw.
And you were so concerned. Mr. Ham, you were so concerned, but you did nothing about it. Right?
We don't see him. They don't come our direction. We don't see Ariel. He doesn't come my direction. When we want to see the grandbaby, we have been going over to the father's house because that's what we were told to do, to go to the father's house if we want to see the baby. Listen, again, Ariel is grown. She says she's 30 years old. She's grown. As a father, we do our best, but when they decide they don't want to listen, they want to do their own thing, you have to respect that as a parent. So I respect their thing. They stay over wherever they are. We stay where we are. They don't communicate with us. We don't communicate with them. Now, that's true. A couple of weeks back, Ariel did invite the mom or my wife to go to Evie's thing, but that's not been the case, and there's not a regular pattern of that. And yes, Terence, they did come over and see Anissa's mom. It's not like we're trying to hold this long feud with them or what have you. We want the best for our granddaughter. If I see Terence, I'll walk right past him. I don't have a problem with him not speaking to me and so forth. So it's not like there's a feud where, there's just ongoing battles. They stay on their side, we stay on our side. That's how it's been for the past probably 6 years.
Do you have, Mr. Ham, do you have any issues with Ivy, or Ivy's mother, or excuse me, Ivy living with her mother?
The only thing, honestly, the only thing that would make me have an issue with Ariel living with her mother is the way her boyfriend acts. That is a very serious concern for me. If you want to know,
I'm sorry, what was that? What was the reason?
I said the only real issue that I have with perhaps Evie being with her mother is the boyfriend and how aggressive and violent he is.
And you're basing that off of that second interaction that you said you had with him. So all this, what you're describing as far as him being aggressive and violent, that's your conclusion after that second interaction that you testified to. Is that right? Is that right? Is that what you're basing that off of?
No. Now can I tell you what I'm basing it on?
Go ahead.
No, not only am I basing it on my thing, but I'm basing it on how he acted when I wasn't there against my wife, how aggressive he was with her.
So, Mr. Ham, you weren't there. You weren't there. So how do you know how he was interacting with your wife?
You're right. I wasn't at his prison sentence either when he did those things when he was younger, so to speak. I wasn't there. But do you not agree that if you see someone had a violent, I wasn't at his prison sentence. I wasn't there when he was, the 2 murders or aggressive this and aggressive that. I wasn't there either. So you say that I can't speak on what I know?
Mr. Ham, were you present when Adrian Maynard had his run-ins with the law? Were you present during those instances?
When only I know about.
Were you present when Adrian Maynard had his run-ins with the law?
No.
Okay.
So
I have no further questions for this witness.
Okay.
All right, thank you. All right, Mr. Ham, you're free to leave.
Thank you.
All right, let's go to the guardian ad litem.
And Judge, I do want to be able to recall one of my witnesses to rebut that testimony, Judge.
Who?
I want to be able to call Mr. Terence King. I mean, if the court feels like, the court has enough evidence, I won't, but, to just leave it at such an allegation that was raised by a witness who was supposed to be sequestered and that watched these entire proceedings after I invoked the rule on the first day certainly would be prejudicial, excuse me. But like I mentioned, Judge, I'll leave it to the court. The court is the trier of facts. But this witness was supposed to be sequestered and he sat here and testified. He watched these entire proceedings. And then here we are with a surprise rebuttal witness.
Okay, let's go ahead and call Ms. White.
Your Honor, I just also want to put on the record, while we were on break, we could very clearly hear Ariel King speaking with Mr. King. So if we're going to talk about who was
no, she was speaking with me. That's why I asked her to mute. She was speaking with me. I logged in and I unmuted myself.
I think I just said call. I think I just said call the guardian ad litem. I think that's what I said.
I would now call Ms. Tory White. Ms. White, if any of this is redundant of testimony you previously gave, please correct me. I can't remember that far back. Ms. White,
I'm sorry not to interrupt, Judge, but can Mr. Ham be excused? Or I don't know if he's going to be recalled, but I just would like to address his attendance here.
Okay, I can excuse him if you think you might recall him, although I'm hoping not.
No,
but
I will not.
Intention to call him, he can remain.
I will not be recalling him. Thank you, Your Honor.
All right, go ahead.
All right, Ms. White, how long have you been a guardian ad litem?
I apologize in advance, Your Honor. My voice is just not cooperating with me. Approximately 13 years.
And what percentage of your practice would you say is dedicated to guardian ad litem work?
99.
I don't need that background.
Okay, thank you, Your Honor. You heard Mr. King's testimony that Iave calls him Terence or Bishop, right?
Correct.
What did your investigation reveal as it relates to this?
Various things depending on who you asked. If you asked the child, Iave, she shared that she was compelled to call him Terence. If you ask her aunt, she shared that she was asked to call him Terence. If you ask mom, there was no compulsion and they ceased it when she began to call him dad. If you ask Terence, he agrees that she called him dad, and he would try to talk her back from calling him dad. And I can't remember if it was dad or father, but some connotation.
All right, thank you. Did you find Mr. King's testimony to be credible as it relates to what your investigation revealed in general?
Objection. Improper questioning of this witness. Your Honor is certainly the determining person about credibility, but for her to ask the gall, did she find somebody's testimony to be credible, is improper questioning of this witness.
All right, I'll restate the question.
Okay.
Were there any inconsistencies that you noticed in Mr. King's testimony with regards to what your investigation revealed?
May I answer, Judge?
Yes, you may. You can answer.
Okay, I apologize. I found Mr. King to be somewhat guarded in his testimony with me, or his interview with me, especially around the focus of his criminal history. Was I put off by his presentation? Not entirely, because he does have a criminal history, and it's my experience that when you discuss that with folks, they are somewhat withdrawn. But when I began to unravel the nature of his criminal history, I thought something more forthcoming would be more helpful.
Okay. Did we, at the last hearing, never mind. You saw Ms. King's interrogatory responses that she was questioned on during her direct or cross-examination, correct?
Yes.
And you saw that she responded no criminal history with regards to the people in her living situation, correct?
That's correct.
Did you find that, or at the time that her interrogatory responses were given, did you find that to be true?
I'm frankly confused about the timeline, and it's not an intentional experience, and I apologize. I'm confused about a number of things. Number one, what was shared with me. Number two, what was shared with the court, and then number three, the interrogatories. They all differ. So I can't really answer that question, only to say that I was told something different than what was shared with the court.
Well, what were you told?
Well, and I always offer the parties an initial questionnaire. Ms. King completed her questionnaire and shared with me that she knew that Terence King had a criminal history and was convicted for attempted murder, or she listed murder. However, on yesterday's testimony, she shared some vagueness about her recollection, and it differed quite dramatically from what she shared with me in the initial experience interview, which was almost 2 years ago. Yeah. So, and I'm happy to share that questionnaire if the court wants me to share screen it, but
I think that would be helpful. Would the court like to see that?
No. I'm sorry, to see what? Oh, I'm sorry, I'm not the court. I didn't.
No, I don't need to see it. I mean, I think Ms. White, your position is, she indicated that it was murder, and I interviewed her myself, and she said she didn't have a good recollection.
Okay. All right, thank you. With regards to your investigation and Ms. King's testimony, were you also able to identify any other inconsistencies aside from the criminal history aspect with regards to Ms. King's testimony and what your investigation revealed?
She lived at a number of places that she did not disclose to the court. And if my recollection serves, the child has lived in 5 residences in her lifespan with Ms. King until now. I'm sorry, 4, and then the present home. So I don't know how you want to calculate that. But that was different than what I heard yesterday.
What was the difference? I think there were yesterday. She did. No,
I'm sorry, you're correct, Judge. It was actually today where she shared that she had lived in one home in transition. So she accounted for two moves on the questionnaire.
No, I think she said 2 since the oh Lord.
Divorce.
Since the divorce. She said 5 over the lifespan and 2 since the divorce, but she said there was a discrepancy because she misunderstood the question.
Fair. Yes, Your Honor. I do recall that.
Okay.
Thank you. And other inconsistencies, just the presentation. She had a more difficult time being forthcoming, and it was just around guarded issues or uncomfortable issues whereas dad was, here it is. By way of example, I offer my folks a share file, and mom uploaded one file of evidence and dad uploaded several. So that was my experience throughout the investigation. But she had some hesitation about engaging more so than dad did.
Okay. You heard her recollection of the story regarding Ivy being burned. You investigated that claim. What did your investigation reveal regarding Ivy being burned?
The child was cooking on an air fryer, and mom was engaged with the child, but not immediately present. So in the vicinity, I will share as far as what was shared with me. And oil is involved, and oil spat out on the child, and it was not a substantial burn in terms of degrees, but she may have been marked for 24 hours, and then it began to heal. The child also conveyed that to Dr. Levy. So in my interview with Dr. Levy conveyed a similar experience. And Dr. Levy expressed some concerns about the child being raised to be so independent, because things like cooking for yourself or bathing yourself are still actions that a parent needs to engage more fully than what mom may have done. So she titled it as neglectful, but yes.
All right. And then I wanted to ask you about prior to yesterday, how many people did you know lived in the home?
Which home?
Miss King's home.
I knew from mother's initial questionnaire, that Melody King lived in the home, Terence King lived in the home, and the child lived in the home with mother. In the pendency of the investigation, Melanie King relocated outside the home. And I knew about one female that entered the home, but only to store items in the basement.
And then after yesterday, how many people did you know who have lived in the home?
I don't know. I think you mean present day. I think that 3 people live in the home. A temporary guest, Terence King.
Your Honor, I'm going to object to the guardian just repeating the testimony of the parties. Now, if she wants to ask the guardian whether
I think you need to ask just specific questions. I've taken very good notes. I'm pretty good about keeping up with the testimony.
I'll move on. Thank you.
Consistency, I make a note of it on my pad, so I keep up pretty well.
Okay. There was a lot of confusion.
But if there's an inconsistency that's going to change, or you're going to ask her if something has changed her rec, then we can go to, that's.
All right, let me skip to that.
If the inconsistency is not going to change her rec, and we're talking about credibility, though, that's my job. So,
sure.
Your Honor, if I may speak to that.
What'd you say?
If I may speak to the recommendation.
Yes.
I did hear petitioner father, his telephone call with mother, and I found it extremely disturbing, and vulgar and inappropriate and unhelpful, especially considering their dynamic. However, given where and I humbly say that thank you for pointing out that my job is very different from Your Honor's. I just make a simple recommendation based on my engagement with the parties for almost a year and a half, and speaking with this child. My recommendation remains unchanged despite the recordings. Does the court need to intervene for this child's sake in terms of the dynamic? Yes, I recommend that strongly. But my recommendation remains unchanged.
And I also, I wanted to ask you as well, because one of the other things that happened between the last court date and this present 2 court dates was the allegation of physical abuse and the bruise. Did you investigate that claim?
Very minimally, okay. Based on the law enforcement involvement, very minimally. And that's usually my protocol, that when law enforcement engages, I defer to their insight. So I know the parties' positions as to what occurred. But I did not engage the child. The child has been put in the middle quite often.
And even after, so you've been made aware of it, the law enforcement, all that stuff, even after the recording, even after this, your recommendation still remains in favor of father having primary custody, right?
Yes.
And if the court were to adopt your recommendation and give our client, Mr. Maynard, primary physical custody of how would you recommend the court implement that?
I'm afraid I don't understand the question. How would the court implement
As
it?
soon as possible this summer? Would you recommend it happen with the sheriff present, with the use of parenting coordinator? These are just some suggestions I'm throwing out there.
I think I referred to some sort of intervention in terms of a parent coordinator or parent counseling. As with most of my cases, I find this family no different. They are extremely deficient in terms of appreciating their roles and how their interaction impacts the child. So whatever decision the court yields, I hope that it includes some sort of intervention in that regard. Whether the court entertains a change of custody, there are several factors that Her Honor will engage. I'm of the opinion that a change needs to occur pretty quickly, only because this kid is dynamic, and I don't know if I emphasize that sufficiently. She is like a sponge, and I don't know what she's consuming in mom's house is the issue that I have, quite frankly, versus what occurs in dad's house. I just gleaned from seeing the other children interact with Ivy and interacting with Alessandra, the stepmother, that things were more purposeful in terms of, and transparent, perhaps is a good word.
Thank you. I have no further questions for this witness.
Ms. White, who called you back to come to trial?
Say it one more time, Ayana.
Who called you back? When you were excused after day one when you testified, right?
There was several back and forth. Mr. Maynard's counsel, Ms. Kreitz, I believe it was Ms. Kreitz and not Ms. Alexander. Ms. Kreitz called me back or asked me to return to trial, and I believe I brought it to her attention that I had been released, and it was my appreciation that I had indeed been released by the court upon the end of my testimony on the first day. And Ms. Kreitz called, I continued to get service by the court, and I think I asked Ms. Marshall, but I can't recall specifically, but I think I did send an email to Ms. Marshall.
Okay, so you testified on trial of day one, and then you were released by the court, correct?
That was my appreciation.
Okay,
Yes.
and so day two, when Mr. Maynard testified, you weren't present?
No, I was not.
Okay. Were you present when Dr. Levy testified?
No.
So you were the first to testify, correct? To your recollection?
I can't recall, and I apologize. I know I was in the first ring of folks, but I can't recall if I was the very first.
Well, let me ask it this way. Did you hear anybody in this case testify other than what you heard yesterday?
Can I look back at my notes? Because I try to take notes while how things are transpiring. Can I look back at my notes, Your Honor? Yes. Okay.
Yes.
Thank you, Judge. Okay, that was on March 16th. But I heard openings. No, I did not hear anyone else.
Okay.
It looks like I should have been the first because I can't take notes while I'm testifying.
Okay. But you did, because I took detailed notes while you testified. You testified that Dr. Levy, you acknowledged that she only met the child in her office for less than an hour, right?
I don't remember the length of time or whether I discussed the length of time with Dr. Levy. I may have, but I just don't recall offhand. I can look at my notes to see if it's mentioned or referenced in my notes, but an hour sounds about right. I remember she took issue with Terence bringing the child rather than mother bringing the child, and mother had tried to reschedule the day before. So that was concerning for Dr. Levy. But that's the only information I have to recollect without looking at my notes, whether.
Can you answer that question one more time? You were going in and out for me.
I apologize, Judge. I can look at my notes and ascertain whether I discussed the length of time that Dr. Levy met with the child, but I can't recall that offhand. I do recall that Dr. Levy took issue with Terence King bringing the child and mom attempting to reschedule the appointment. Those were red flags for Dr. Levy, excuse me. But I can certainly look at my notes and see if she talked about time frame with me in my interview with Dr. Levy. If
I
the
mean,
court wants me to.
that's up to the courts of whether you can use your notes or not. I just want to explore, what you're testifying here today, because you said your recommendation hasn't changed, right?
Correct.
In your recommendation, you said this recommendation is premised on the court's finding of a material, and you put that in italics, of a material change in circumstances to warrant a change in custody. The Gaul remains unconvinced such a change exists. Those were your words, right?
Absolutely, but that's not my role.
I understand. You said your recommendation didn't change, and I just wanted to
yes.
show you what you stated on your recommendation, just in case.
Yes.
Here, Gaul
Yes.
recommendation. Down here, that was the last paragraph you mentioned to the court. This recommendation is premised on the court's finding of a material change in circumstances to
Okay, Your
warrant
Honor, I'm going to
change in
object. This is
custody.
badgering.
Gaul
And-
remains unconvinced such a change exists.
Your
That
Honor.
is your recommendation on the
Overruled.
screen?
Overruled.
It is, and if I can explain, I don't walk in the court's domain or jurisdiction. I can only, and if you'll scroll down to that third page on my recommendation, I do a matrix, and I best interest X's in terms of the standard. So I can only speak to what the analysis is as to the standard, and it is the court's role to determine whether a change has occurred or not. So I don't walk in those waters. I just simply deliver what the facts determined and analyze those facts.
I don't remember this matrix.
It's part of the recommendation that I sent to the parties. And it's not a recommendation, Your Honor. It's just a simple outline of the best interest standard. And then facts that I gleaned from the investigation popped into the standard. It is not a complete recommendation, if you will, in terms of a thorough analysis that the court is witnessing or experiences more often.
One of the things you checked as far as an X on the criminal history, you put an X under father's column. Why did you put an X under father's column for criminal history?
Because, and you'll have to remind me, I can look again, I don't have it in front of me, but because of Mr. King's criminal history, not mother's, because mother and father were arrested at the same time, so I would check both, but it was because of Mr. King's criminal history and considering the turpitude of the crimes raised, I did not check in mom's column because he lives in the home.
One of the questions I asked you, and you can double check your notes, whatever you need to do, but Ms. White, I took very detailed notes on your testimony. One of the questions I ended your testimony with was whether you had any, I asked you specifically, because you described both parties' home environment, because you visited mom and dad's home, right?
That's correct.
I asked you, I said, were there any danger or safety concerns in mom's house? That was the last question I asked you. You said no. Is that still your testimony today, that there are no danger or safety concerns in mom's house?
That has remains unchanged. Right.
Okay. The other question
I believe in
asked you
redemption.
I'm sorry?
I believe in redemption. And quite frankly, as evidenced by the recording yesterday, both part and Mr. Ham's recollection of events, his events that he shared with me that occurred actually before November 2022, which is when I interviewed him. He shared the similar circumstance about Mr. King threatening him and Ivy being present. I think both of them could benefit from some insight management about escalating tensions and how important it is to resolve the child's experiences against what they are putting out. So both of them could benefit from that.
Ms. White, let me
last
ask
time
you a question. Based on how Mr. King testified before the court, he appeared to be level-headed, and he appeared to seem to have a need to nurture a father-son relationship. When you interviewed him and talked with him, is that the demeanor that you received?
Yes, that he was nurturing, that he was probably more involved with Ivy's care. However, to note for the court, at the time that I investigated the issue, mom was working outside the home, so she relied more frequently on Mr. King's assistance. I did find him to be nurturing. I found his involvement a bit too much like dad. I saw a video over Father's Day where he was just engaged with her as a father would be. But in terms of boundaries, quite frankly, both of these parties could experience some improvement. Mr. King, unfortunately, his involvement with Melody King and Ariel King was a bit glazed over. And he did not present that as forthcoming as I believe he could have. Is that an area of discomfort? Certainly. But his regard for the child was very loving, very supportive. And I think if I remember correctly, he attended school events on her behalf. I think it was a PTA meeting or a parent-teacher conference. I can't recall, again, without looking. But in other words, he did all the parent things that perhaps the court is interested.
One of the things I wrote down from this was before questioning, when you just kind of gave your testimony to the court before the lawyers asked you questions. One of the things I wrote down, you said Evie is fond of him in reference to Terence King. You said Evie is fond of him. They joke. She looks at him for a direction.
She does. Yes.
Okay.
Oh, I'm sorry, Miss Barrie.
No, you were answering what I was going to ask you.
Okay. She absolutely does. She looks at him for guidance. I recall, I will say that when I talked with Dr. Levy, she was a bit concerned that Evie regarded him a bit too extremely in terms of direction. So it's not to say that I think it's inappropriate or untoward. I'm not in a position to gauge that because I'm just a JD. But Dr. Levy's experience was a little much. And so again, that informed my opinion about the transparency in the home, and what is actually going on versus what is revealed. I just found a disconnect. But Ivy absolutely looks towards him for guidance. She relies on him. I'm not ascribing any inappropriateness in that regard. I will say, at the meeting with at the home visit with Mom and Mr. King, Ivy is very dramatic, and she introduced me to Terence, and she used the term Terence. She did not call him Dad at the home meeting. So I don't know what the court is concerned about necessarily, but I will say that she used the term, the child used the term Terence.
I want to ask you to see if this was consistent with your discussions with Dr. Levy, because the judge actually questioned Dr. Levy when she testified, and one of the questions to Dr. Levy was, like whether Dr. Levy had any concern based on the relationship, referring to Melody, Ariel, and Terence, whether Dr. Levy had any concern or saw any concern based on the relationship. For example, are there too many people coming in and out of the home, other than the fact that Ivy may be confused as to the label of the caregivers in the home? Do you see anything wrong with mother's lifestyle to that extent that it affects Ivy? That was the question of Dr. Levy, and Dr. Levy responded, no, I cannot make that judgment. I can't say the lifestyle is wrong or harmful to this child. Is that consistent with what Dr. Levy shared with you?
Yes, entirely. And why I recommended Dr. Levy to perform this type of engagement with Ivy is Ivy shared with me that it was unusual to see mommy kissing Mel versus mommy kissing Terence. And I didn't know what to do with that. So I wanted her forensic opinion and insight to determine, for the court's benefit, whether the relationship impacted the child negatively or positively.
Well, Ms. White, the last time we were here, that I asked you the question, and I think your motion also indicated this, your motion for an evaluation. I asked you, how did Dr. Levy get involved? You actually told the court that Dr. Levy got involved because Ivy, my client, Miss Ariel King, told you that Ivy was making statements to her that was fed by her father. So you wanted to make sure what exactly was the truth. That's why that's what you told the court last time we were here, the reason that you requested Dr. Levy, right?
Levy, yes, it was both. I was concerned in conjunction with what Mother shared with me at I think it was her meeting in my office, if I recall, that Mother shared, and there was the whole experience, and I can review that, but I don't want to belabor the point. But Mother shared with me that she believed that the child had been coached by Dad, and I didn't know. It informed my regard similarly. I didn't know what, and if anything, the child was sharing with me was untrue, was coached, was overemphasized. I did not know, and so I needed the forensic insight to simmer me down and tell me, no, things are fine, or there is a concern. I did not know.
Okay, because this is the first time I've heard you say that you wanted Dr. Levy's opinion because Mom was kissing a girl. You didn't say that last time we were here. Why not?
No, it's an incident that occurred and the child shared with me, but it wasn't in the entire impetus of my engaging Dr. Levy. And I'll say it again. My concern was whether the child, what I was receiving from the child was accurate, or was it informed by others emphasizing things. And so I needed Dr. Levy to sort of break that apart, which included the child sharing with me. And I've forgotten how she phrased it. I can look at my child notes, but she said something to the effect of it was, no, here's what she said. She said, I thought only boys kiss girls. And I didn't know if dad told her to say that because of the experience that I just referenced, or I didn't know if the child actually witnessed that and was she really impacted by this relationship. But yes, both are true, meaning, yes, I needed insight and correction about what the child's experiences may have been beyond or because of the relationship.
Well, Ms. White, I'm asking you, why didn't you tell the court that the last time when you testified for almost 2 hours? Why didn't you mention that?
Why didn't I mention?
Why didn't you mention the fact that you now say that the child told you that she, about mom kissing a girl versus a boy? You didn't say anything about that last time we were here. Why not? Why are you bringing it up 7 months later? Or 9 months, because that was March. 9 months.
I'll restate it again. Maybe because it wasn't relevant. After I investigated the concern, it wasn't relevant. And I'm not going to rehash all of my experiences for the court. We'd be here 7 hours. I interviewed almost 11 people, I believe.
No, I was just asking you specifically about that incident. I don't know why you're back here either. I get it. My question was about that particular issue.
Please don't interrupt me. I'm in the middle of sharing for the court my inside experience.
Issue. I said 1 moment. All right. Ms. White is an officer of the court, and you got to let her finish.
I understand, Judge. I just wanted to make sure she understood my question. She started to get into other issues I didn't ask her about.
All right. Go ahead, Ms. White.
Thank you, Judge. My position is and remains, I'm not going to rehash everything for the judge. I only will share with her what I believe is relevant. If the attorneys want to inquire of me differently or probe something or flesh something out, that's your job. It wasn't an issue for me in terms of this investigation. I'm very clear on the law and the standard in terms of relationships and avant-garde relationships. So I wanted to be very delicate and purposeful about how I address this concern. And because I did not reference it in the first experience means that it wasn't important, or I would have. I'll raise it now because you probed me differently, and I'm addressing your concerns, I believe, appropriately. The child raised it, and I didn't know what to do with it. And I humbly say my experience does not lead me down that track. Again, I'm just an attorney. And that's why I engaged Dr. Levy to help me better appreciate the relationship, her candor, her presentation, because she's very dramatic, this little girl. And oftentimes when I get the more spirited child, I don't know what is informed by her sentiments, individual sentiments, and whether or what the parents have provided for her, or whether she's putting on a show. So I think further examination is required.
Yeah, have you been communicating with Adrian Maynard since the last time you were here in court?
I did 1 or 2 times, I can't recall, about the incident of the bruise. And it may have been twice. I have to go back and look at my contact log.
Did you talk to him about a fall break issue in October of this year?
I knew that something occurred. I think someone sent me an email. Again, I can't recall. I really did not ascribe too much importance to the issue because they had experienced a similar issue in 2022. Not to say that either is not important. It's just a signal to me that this dynamic is very poor. So someone sent me an email. I just can't recall whether it was Adrian Maynard or Miss King. I can't recall, but I am aware of it, that they didn't meet have a meeting of the mind, so to speak.
Okay. Did you talk to Mr. Maynard about Ariel King being secretive or having secrets or some issue about the veil of secrecy? Did you have those communications directly with Mr. Maynard?
I can't recall if it was Mr. Maynard or was it with Dr. Levy. I'm aware, and I don't want to go too far into it, but I'm aware that the child has been imposed by both parents about secret keeping and household management, if you will, of information sharing. And I asked Dr. Levy about that specifically. and she didn't have an opinion about who was telling her to keep secrets and whether there were witches that told her not to reveal things. She didn't have an opinion about it. That and the grandparents, she said she didn't have an opening to probe the child about. So it wouldn't be natural, in other words.
Did Mr. Maynard tell you that he changed religions?
Well, I knew that he was a practicing Muslim by virtue of the investigation, but I don't know, and I can't speak to when that occurred, that his religion. But when I started investigating the case, he was already practicing Muslim.
Okay, so you don't have any, you can't speak to whether he informed Ariel King about his change in religion. You can't speak to that? Okay.
No.
I want to ask you, the last time you were here, because I just want to make sure I don't have any other surprises or nothing else has changed. The last time you were here, one of the things you testified to was, and the court even inquired a couple of times during your testimony, was during your investigation, is it not correct that you mentioned that you knew that Adrian Maynard knew of the trio relationship that my client had prior to the divorce?
Yes, I think that's accurate. Adrian, and I don't want to put words in your mouth, but I think you're asking me whether Adrian knew about the multiple partners or different relationship. And I believe he had information to support an inference that there was a different type of relationship going on prior at the time of divorce, or and I can't remember whether it was at the time of the parenting plan, but at some juncture or point along the divorce process.
Okay, well, last time you were here, the judge was the one that asked you. She said, well, how did you know? And you said that he told you. Y'all talked about it. You and Adrian Maynard, correct?
Correct. Yeah. Well, it was in an interview, or it was either in an interview or an email or some form of communication. I can't remember if it was as purposeful or as specific as we talked about it, but the information came from him to me in some fashion.
Okay. In your interview, you said well, excuse me, let me ask you this. In your interview, in your investigation, you interviewed Otto Ham?
I chuckle because at the time he was Trey Ham to me and not Otto Ham, but I did interview him circa November 2022.
Okay. And in November 2022, did he tell you that Terence King threatened to break his jaw?
He didn't say jaw. He said he threatened to hit him, but he didn't use jaw.
In your investigation, is it correct that you mentioned that you were aware of some, I guess, the issues that Ariel has had with her side of the family? You were aware of that, and you were aware that it pre-existed the divorce, right?
No, I wasn't aware that it pre-existed the divorce until today's testimony. I was aware that she had a fractured relationship with her parents and her sister. That was learned during the pendency of my investigation, but I did not know that it pre-existed because I believed until today that the parents were very involved in sort of moving her from Texas, and then baby coming and grandparents loving on the new baby at the time. And so no, I was not aware that it predated. And that's my fault. I don't believe I ever asked her in terms of timeline when the fracture occurred.
Okay, what I wrote down, you said that you were aware that the estrangement, that's the word you used. Mm-hmm. You were aware that the estrangement, when I asked you about her family, you were aware that the estrangement existed prior to the divorce. That's what you testified to back in March of this year.
I may have said something along those lines, but if you also will marry what you said as my statement, and I don't have to trust you that you took just detailed notes on what I was saying. If you'll marry the fact that the timeline of the divorce is rather spurious. She was pregnant, moved from Texas to Georgia, and then it gets a little fuzzy. She and Adrian Maynard still have engagement, probably not physical, but they still interact. So my position is that when they actually separated physically as a couple is unclear to me. I know that the estrangement happened prior to inking of paperwork, because at that time there was a clear demarcation, if you will, that Miss King had moved on in a different type of relationship, which was unsatisfactory to her parents.
Let me ask you along those lines. I think Miss King indicated that her parents were Jehovah's Witness, and that that was one of the reasons for the breach or the estrangement in the relationship, or some of the issues that they were having. Was the family bothered by the fact that there was a divorce? Did you
A divorce between Miss Maynard and I'm sorry, I'm so
Yes.
sorry. Adrian Maynard and Miss King?
Yes.
No, they weren't. And this judge comes from, is it Anissa? Anissa? I don't know the pronunciation.
Mhm.
But this comes from Miss King's mother, that they were not dissatisfied. They were alarmed by a divorce because they believe that, or at least according to her, they believe that they had their typical fights as a couple, but they did not believe that it extended to the scope of a divorce. But no, they weren't unhappy because they recognized that it was difficult for both of them, and remained supportive of Adrian Maynard beyond the divorce. Tried to engage with Miss King beyond the divorce, but they weren't upset about it.
So the reason I'm asking about that, I'm trying to wrap my head around it, because it sounds like Mr. Ham's position was he supported the child being primarily with dad because of this one fight. And it just seems odd to me that one fight would cause a parent to say that. I mean, if you might not like the person that they're with, but for you to make the suggestion that the child would not do well there must be something. Was there and then he mentioned something about an investigator. Did they do an investigation into them or something?
They pulled a background report on Mr. King. And they were alarmed by initially Mr. King and Miss King's age difference. Then they were more alarmed. This is according to Anissa, not Mr. Ham, or Otto Ham. They were alarmed because of Miss King's retraction or removal from their lives, and they believed that was guided by Mr. King, Terence King. So they slowly but surely became more concerned as a parent that perhaps Miss King was under Terence King's influence, because she was more she was just removed, and
I remember now.
That gave them pause.
Yes, I remember now that some of that testimony. Okay, thank you.
Yes, Your Honor.
Okay, now that kind of, all right.
Ms. White, may I confirm the last time that you spoke to or met with a minor child?
Oh, goodness. Before she met with Dr. Levy, to give the court some context, maybe the dates won't be, well, no. I think I saw her at one of the parents' homes after Dr. Levy. And I can go back and look. I keep a detailed contact log because I can't keep all my cases tight, but I can look at my contact log and it will share the dates and times that I did either. But it's been a while. It's been a long time. I engaged with the parents only recently because of the bruise. But before that, I did not engage with the parents at all after the first trial, the first date of the trial, and probably did not engage with the parents until right before the trial. So IEVI would have had to have been January of 2023.
Yeah, that's what I was going to ask you. That's what I wrote down, was the last time that you met and talked with her was January 2023. So I just wanted to make sure you haven't seen her or talked to her since then.
No.
Okay. And you haven't been to either parent's homes since you did your home visits in 2022?
No.
Okay.
No.
All right. Thank you, Ms. White.
All right. So what I'm going to do is we're going to take an hour break. I'm going to ask you all to come back at 4 o'clock. We'll do the closings at 4 o'clock.
Your Honor, am I excused?
I don't see any reason why we need Ms. White. And I thought also, even the last time the court excused you, I only would have excused you if you all agreed. So I just want to put that on the record. There was an agreement for her to be excused, right?
There was.
There was, Judge.
Okay.
I'm sorry. I'm sorry. Yes, but there was.
Okay. I just want to make sure. Okay, great. Thank you so much. I'll see you guys back here at 4.
Your Honor, I'll be reserving.
All right. Ms. Claret?
Yes, Judge, may it please the court. And I know this case has spanned over the course of 4 days. And on behalf of my client and myself, we just want to thank the court for the court's patience in presenting our case. As I mentioned on day 1, Judge, when we came here back in March of 2023, this case is a case of a father, a non-custodial parent who just wants a second bite out of the apple.
That's why we're here. In fact, when we started, both sides on day one, both sides started with opening statements. I raised the issue that there's been no material change in circumstances. Before we even got into the litigation of the case and testimony and such, the court itself, on its own accord, the court specifically asked opposing counsel, what are the material changes? What's being alleged? I want to know what the material change is. We had a whole dialogue back and forth before we even swore in the first witness, which was Tory White, the guardian. And there were 4 things that was articulated to this court by the petitioner. One, the petitioner mentioned the environment of the mom, indicated that there were multiple partners in the home. The second thing that was indicated was there was the allegation that the child has changed schools multiple times, and there was a concern about educational stability. The third thing that was mentioned on day one, when the court inquired, the opposing party said the third thing was denied visitation, that mom interfered with visitation. And then the indication that there was a time in 2021 that related to COVID, and then there was an issue with fall break. And then the fourth thing that was mentioned to this court was issues with access to records. Dad was alleging that there were issues with access to records. So then the court turned to the guardian because the guardian was court ordered through this case. Halfway through the case, father filed for a guardian. We objected to the appointment of a guardian. The court, without a hearing, just based on the pleadings, went ahead and appointed a guardian, made that fully responsible for those expenses. So he's paying the guardian. As it relates to the guardian's testimony, after she testified, Your Honor then came back on its own without either counsel prompting the court. Your Honor came back on its own and then went through a summation of what the court's position was at that time. And I specifically took detailed notes because that is why I ultimately did a motion for a judgment, motion for a directed verdict after the petitioner's case. But before the petitioner even presented his case, what the court went through after the guardian's testimony was that, the court indicated that when she initially heard what was being alleged, she thought that the material change was the poly relationship. And then the court indicated, but per the gall, dad was aware and consented to the arrangement, recognizing that people would come in and out. And the court said, so where's the material change? Then the court addressed the school. The court indicated that there was allegations about school, but it was daycare and not school. And the child was 6. There was no change in school. It was a daycare change. Then the court went on to address that even if there was a change in the daycare curriculum, it wasn't a change in school. Then the court further indicated that based on the guardian, any change in daycare was not due to moving, or it wasn't because the minor child was flunking. It was because the minor child needed a better curriculum. That was what the court gave as feedback. Then the court also moved on to the next issue regarding visitation. And the court indicated that with the COVID exposure.
I'm sorry. Can you hold it one quick second, please? You may continue.
Then the court addressed the next issue, which was the allegation about denied visitation. And the feedback there to the parties was that the visitation was related to a COVID exposure, and that happened to everyone during that period of time. And then as it related to the records issue, the court indicated to the parties and everyone at that time that the record issue or access to records seemed to be more of a contempt issue unless there was any proof that it interfered with dad's visitation. And then the court rested with that because there was a mention that Dr. Levy had expressed a concern, then the court would proceed with the trial to hear more evidence and to see, what effect, if any, the concern that Dr. Levy had on the minor child would have overall. And so the court indicated that you would give everyone an opportunity to speak. So here we are. And then the trial ensued with the first witness, thereafter the guardian, the first witness being called by the petitioner. The case that I put forth to the court is a Georgia Court of Appeals case. It's a 2019 decision. It's Burnham v. Burnham. That citation for the record is 350 Georgia App 348. Burnham v. Burnham is still good law. This decision is quoted in so many different custody cases. And in this particular decision, the Court of Appeals indicates that once an award of child custody has been made, when the non-custodial parent seeks to change that arrangement, the trial court must first determine whether there has been a material change in circumstances affecting the child's welfare. And it goes on to cite the Supreme Court decision of Viscup versus Viscup, 291 Georgia 103. That's a 2012 decision. The Burnham court indicate that the standard remains that a change of custody may be granted only if A new and material change in circumstances affects the child. The trial court must find that a material change in circumstances has taken place before it can consider whether a modification of custody is in the children's best interest. And so what we have here is a two-part test. And so when we look at this two-part test, the marker we're looking at is when a divorce decree was entered. We all know it was entered August of 2019. It was entered by a settlement agreement. It was not a contested trial. It was not an adjudication by the court based on any hearing or testimony. It was a consent agreement where dad and mom consented to mom having primary physical custody of Ivy, and they consented to both parties sharing joint legal custody with mom being tie-breaking on all 4 areas. That is what both parties agreed to August of 2019. So when we look at whether there's been a material change in circumstances, I'm going to take it topic by topic. The first issue that has what I believe to be a red herring in this case is this polyamorous relationship. So this polyamorous relationship that dad wants this court to believe is a material change. Well, the guardian testified on day one. On day one in March of 2023, which was closer in time to when she completed her investigation, closer in time to when she last met with the minor child that she says was in January 2023, she testified that in her investigation, she was aware that Melody and Terence King were present prior to the divorce. She tried to say something different today, but then when I asked her about it, then she, came back and tried to change her testimony and said, well, yes, I knew that they were in a relationship with Ariel King mom prior to the divorce. And so then she also mentioned that day one of her testimony, that she became aware that mother and Terence were living together prior to the divorce as well. That's what she uncovered during her investigation. She also mentioned that day one of her testimony, she mentioned that father was aware of multiple partners. And the court interrupted. The court specifically interrupted and looked up and said, well, how did you know that? And the guardian's feedback, because I wrote it down, she said that she confirmed that dad knew about multiple partners already in her communications with dad. That's how she knew. My client also testified that dad knew. Dad testified, and he couldn't refute the text messages that they did talk about dating people openly. Ms. King testified that when they were married, they physically separated when she was 6 weeks pregnant with Ivy. Ivy was born February 24th of 2017. So they physically separated in 2016 when she left Texas to come to Georgia and separate from her husband. During that period of time, the text messages that we saw that were entered into evidence, specifically text messages, Exhibit 15 that was entered into evidence and Exhibit 17 that was entered into evidence, was very indicative of the fact that Mr. Maynard knew that mom was in a relationship with other people. We saw those particular text messages, specifically April of 2018. When we look at the text message that was entered into evidence, April of 2018, before the divorce decree was even finalized, looking at this text message here, when they're discussing exchanging Evie for weekend parenting time. If you scroll down, looking at it in that same text, dad says, don't forget the part where you were leaving to go be around another man whom front of my child. Also, that you confirmed that you spend time with said men regularly after we had agreed that that was unacceptable. And then mom responds to that in text and says, Adrian, your own family was unable to calm you down. We agree on a lot of things. You asked if you could see her. There you go. Dad goes on back and forth to talk about mom and what he thought of her. He said, and I highlighted it here, that mom was the best mistake of his life. That's what he said. And then the parties went on to talk about divorce and filing for a divorce. Then we also saw Respondents Exhibit 14. In particular, Respondents Exhibit 14 that was entered into evidence was a text exchange between the parties before the divorce was finalized. Specifically, July 1st of 2017, the parties were texting back and forth. Dad specifically asked mom, that's your boyfriend or BF? Mom responds, huh, best friend or boyfriend, because he's neither. Then dad asked her, this is who you were going on a date with? And mom states in the affirmative, yes, it is. Then dad says, okay, cool. Thanks for the heads up. That's what dad's response was in this exhibit. When mom and dad discussed during the marriage that mom went on the date, dad's response was, cool, thanks for the heads up. Ivy was born at that time. This is July of 2017. Ivy had already been born at that time, and these parties were having discussions about other people. Then we look at further discussions between the parties in July of 2017. Specifically, when we scroll down, mom then says, we have had full talks about Alexa, which is dad's wife, and how you feel about her. I can only assume jealousy, but I'd really like to know why this bothers you so much. Then dad goes on, I was just asking. I saw he texted you the other day asking about Ivy and stuff. So I just assumed. And then mom questioned that he was my BF, and dad's response, that NIGHA, you're dating or whatever. And then when they continue, dad says, I don't like the idea of anyone around my kid, but you got to do what's best for you. That's what dad's response was in July of 2017. That's what dad's response was in April of 2018. So for him to come before this court now and say that he had an issue or that he didn't know about any other men or any males being present or that there were any other men around the minor child just isn't true. The evidence in and of itself shows otherwise. But when we get back to the issue of the polyamorous relationship, there has been no evidence whatsoever that this has caused any emotional harm to Ivy. The only witness who has said before this court that it caused Ivy emotional harm was dad, the person that's trying to change custody. In fact, I asked the guardian on day one, and I asked her again today, was there any concern or issues with Ivy's mental health? She affirmatively answered no. Even as it relates to the poly relationship, what the guardian testified on day one, she said that Evie sees the other people as friends of mother and they are loving and caring to her. That's what the guardian said about the poly relationship. Then we have Dr. Levy. Dr. Levy testified on day one of trial. The guardian wasn't here to hear that. But during her testimony, Dr. Levy admitted that she only met Ivy once. It was less than an hour. It was in her office. She did not meet her thereafter. She did not see her in mom's home, dad's home, no other time. And so initially, Dr. Levy indicated that with her concern was that she did not find that Ivy knew age-appropriate things. And so I inquired about that. I said, well, what do you mean age-appropriate things? And she said things like letters, colors, age. And so she also mentioned that she thought Ivy was confused about what grade she was in because she kept saying she was in first grade when she was in kindergarten. So then I explored further. I said, well, Dr. Levy, did you realize that Ivy is in kindergarten, but she takes first grade classes? She had to answer in the affirmative that that's what mom told her. And that's what the evidence showed. And that's what the guardian testified to. I then asked her, well, what other concerns do you have about Ivy? Bullet point them for me, listed. Dr. Levy's mentioned three things. She said, one, it seemed like mom was letting Ivy care for herself. Two, she had an issue with the corporal punishment at both homes by mom and dad. And three, the time, she just mentioned a time where the parents were fighting. And I specifically asked, did you have any other concern? She said no. There was no concern that Dr. Levy mentioned as it related to the minor child's emotional state, her mental state. There was no evidence of any abuse or neglect in mom's home. In fact, Dr. Levy never even went to either party's home. The thing that Dr. Levy indicated was that the reason she came onto the case is because she had a referral from the guardian. And so I asked Dr. Levy after her meeting with Ivy, whether she met with mom to follow up to get any context to the things the minor child was saying, whether she met with dad thereafter. She specifically indicated that she did not, that she just met with the minor child and then reported to the guardian. Well, one of the issues that came up during day one of trial and that I raised was the fact that there was some coaching on behalf of dad. And when I asked Dr. Levy whether or not she had found that to be the case, and I think the court inquired as well, she indicated that she didn't find that there was coaching, but she did find out from the guardian that dad did prep the minor child when she went to go see Dr. Levy. Now, as it relates to any other issues that Dr. Levy raised, the court indicated, other than the fact that Ivy was confused as to the label of the caregivers, the court inquired with Dr. Levy, did you see anything wrong with mother's lifestyle to the extent that it affects her? Dr. Levy specifically said, no, I cannot make that judgment. I can't say the lifestyle is wrong or harmful to this child. That's what Dr. Levy indicated. I will say there's been no evidence that there's been a recommendation for the minor child to have therapy. There's been no indication that for the minor child to undergo any mental health or emotional treatment. There's been no indication by Dr. Levy that the minor child needed to seek any other professional. There's just been no proof whatsoever that because mom is in a polyamorous relationship that dad introduced her to, that she learned about through dad, and it's unrefuted that she learned about that through dad. I think dad even indicated that he showed her some stuff online. There's no evidence whatsoever that mom's relationship or her poly relationship had any effect on Ivy whatsoever. As it relates to the issue of whether or not polyamorous relationships would be a material change, I've been able to find some case law that is very similar to this particular case. The one that I would like to provide to the court is two cases. The first one is Moses versus King. That case citation is 281, Georgia App 687. It is a 2006 decision. It is still good law. This case dealt with same-sex cohabitation. And the rule of law that this case stood for is that same-sex cohabitation alone is not enough to change custody. In this particular case, the father filed to change custody because mom had custody from a previous legitimation order. Dad filed 2 years later to change custody. He alleged that mom had become irresponsible. He said that mom failed to provide adequate care for the child, has had 4 same-sex domestic partners, of which the most recent lived in mom's household with the child. He mentioned that that the child was in the continuous company of gay and lesbian adults. The allegation in that case as well was that mom leaves the child alone with other adults for long periods of time. Mom failed to provide basic physical needs. The child's grades had dropped, and that the minor child, who's 12 in that case, expressed to dad that she wanted to live with dad. And then also in that case, dad had married and had 2 children with his wife and provided a stable home environment for the minor child. Those were the factual circumstances in that particular case. The trial court actually granted that change of custody, finding that mom was in a meretricious relationship with a same-sex partner, and actually changed custody. The case was appealed to the Court of Appeals, and the Court of Appeals reversed that change of custody. The Court of Appeals indicated that there was no evidence in the record that reflected that the facts were new or that it demonstrated a material change in circumstances. And the reasoning was that Georgia's appellate courts have held that a parent's cohabitation with someone, regardless of that person's gender, is not a basis for denying custody or visitation, absent evidence that the child was harmed or exposed to inappropriate conduct. And in that case, the Court of Appeals reversed the trial court's change of custody and ruled that the custody should have remained with mom because there was no material change in circumstances. The other case that hits on the same issue is the case of Cooper versus Cutler. That is a more recent decision. It's a 2016 decision. That case citation is 335 Georgia App 827. And in that particular case, dad in that case as well filed for a change of custody, stating that mom had some live-in partners. And in that particular case, the trial court actually denied to change custody. And the court reasoned, and the Court of Appeals affirmed the reasoning that live-in relationships by themselves do not warrant a change of custody. The relationship must affect the child's welfare to support modification. And then the court went on to state that there's no evidence that mom's romantic relationships negatively affected the child. And that the evidence showed the child had a strong bond with mom's ex-stepfather or her new domestic partner. In this particular case, that's exactly what we're dealing with here, Judge. There's been no evidence whatsoever that this polyamorous relationship that mom is in has had any effect on the minor child. In fact, the testimony has been that this minor child is thriving. She's doing well. She's excelling in school. She has won multiple awards in school. We saw the awards. That was Respondents Exhibit 40. The time that mom changed her school from Choice Preparatory Academy in kindergarten that first semester to the second semester, the very second month that the minor child was at that school, she became Student of the Month. In fact, she has been thriving so well that at her honors program, she was listed on the program. We saw that program. She was listed on the program and gave the welcome to an entire audience. And this is a kindergartner who just started at a new school. And so when we look at her achievements and her educational level, we saw their certificates where she had advanced reading. We saw the actual banner where it was a certificate of excellence or achievement. Those aren't signs of a child who is suffering or who has any mental harm or adverse effect from this polyamorous relationship. In fact, just like the guardian said, Ivy has a close bond with Terence King. Ivy sees mom's partners as friends of mom, and she said that they all love and care on her. There's no evidence whatsoever that a polyamorous relationship has had an effect on Ivy. Now, the next topic I'll move to is Mr. King, Terence King, because what Mr. Maynard wants to make this case about is he wants to make it about Terence King and not what's in this minor child's best interest. Mr. King testified. Your Honor heard about him before he testified. Your Honor got an opportunity to see Mr. King, hear him, assess his demeanor, give consideration to his credibility, and hear what he had to say. Now, Mr. King, he admits that 27, 30 years ago, yes, he had a criminal history when he was 16 to 17 years old. But what I also heard him say was that's something that he was not proud of. But what he has used and what he has told this court is he has used his past as the run-ins that he had as a teenager. He's used that today for good to mentor youth, to establish youth programs, to educate youth who may have experienced the same type of run-ins with the law that he experienced. He testified that it happened back when he was in New Orleans. Given the circumstances for the guardian to make the feedback to the court that he was, not forthcoming or not hesitant, it's not a badge of honor. He's not coming before this court bragging about his past. He said that it was 30 years ago when he was a teenager. That's not a badge of honor. That's not something that you just boast to anyone asking you about. And dare I say that he's probably shameful of it. But what he did mention and what he did indicate is that he moved to New Orleans to get away from all of that. He met my client in a mall. It's not like they met in some, unsafe environment or some risky environment. He testified that he met my client in a mall. She was there shopping with Ivy. They exchanged numbers. They talked for some time. They started dating in 2017. He indicated to this court that he has been in Ivy's life since before she was 1 year old, since 2017. He testified that in 2018, they moved in together and they all started living in one roof. And that was before the divorce. That was Ariel King, Mr. Terence King, Melody King, and Ivy. They all lived as a family unit together in one household since 2018. There's no evidence that Mr. King has harmed this child. There's no evidence that this child hasn't been safe in that household. In fact, I asked the guardian back on day one, and I asked her again today, do you have any safety concerns or danger concerns of mom's household? She indicated no. Her description is in her written recommendation, and she testified on day one. She described mom's home as comfortable. She said both homes were comfortable. When she described Ivy's room, she said Ivy's room was light and airy, and it was the most comfortable room in the house. She said there was plenty of clothes and toys. I asked her, did Ivy, was there food in the home? Because there was allegations by dad that maybe there wasn't appropriate food in the home. She indicated on day one, there was food in the home. It may not have been food that Ivy liked, but there was food in the home. And so when it comes to Mr. Terence King and all these allegations that dad wants to raise before the court and paint him out to be somebody that he's not, Your Honor saw the photos. We presented photos. Respondents Exhibit 12 showed photographs of the relationship that the minor child has with dad. It wasn't just dad's testimony. It wasn't just the guardian or my client's testimony. Your Honor saw the photos herself. The photos by which Mr. Maynard wants to cause the issue about saying that that Mr. King takes photos and videos the minor child. We saw the photos that were taken. And we saw we saw her emotions, we saw her reactions, we saw that she was there with mom's side of the family, we saw that she was there with Mr. Terence King's mother, we saw her photographed in different settings with friends, family. There was no indication whatsoever that this minor child was in any harm or danger in Mr. King's care for the past 6 years. In fact, it's very interesting that in August of 2019, and it wasn't clear whether it was before the divorce or after the divorce, but in August of 2019, when mom and dad, Mr. Maynard and Ariel King, had some sort of altercation and were arrested and taken off to jail, it was Terence King that came to the rescue. He testified he's the one that pulled up. He's the one that took Ivy with him. He left with Ivy. It wasn't Mr. Maynard's wife, Alexa. It wasn't Mr. Maynard's side of the family. In fact, we haven't heard much about Mr. Maynard's side of the family. It wasn't mom's mother who came. It wasn't mom's grandmother who came. It was Terence King. And so for Mr. Maynard to 2 years later say that he has an issue with Terence King when he's the man that actually came and made sure that his daughter didn't go to DFACS when mommy and daddy went to jail, for him to now raise that issue before the court, that's just disingenuous. Now, there has been no testimony whatsoever that since this man has been in Ivy's life, that there has been any threats or harms to Ivy. The guardian testified that Ivy's fond of him and he's fond of her, and that Ivy looks to him for direction. Now, throughout this trial, Mr. Maynard has tried to present evidence and indicate that Mr. King forces Ivy to call him dad or whatever the case may be. Ivy is now 6 years old. Mr. King indicates that, yes, he's been in her life since she was an infant. And there was a couple of times where she tried to call him dad and he corrected her. Why did he correct her? He said he's a dad himself. He's raised kids. He even has a daughter who became a lawyer. He mentioned that he could understand how Mr. Maynard would feel because he's a dad himself. And he corrected Ivy and told her, you have a dad, I'm Terence. The guardian indicated even today, she indicated on day one, she indicated again today that when she came to Ivy's home, Ivy introduced Mr. Terence King as Terence. That's how Ivy introduced him. Now, if the minor child just says on her own, oh, that's my dad, like Mr. King indicated, she said that to her friends on the playground, or if she even goes to Mr. Maynard's home and calls his wife mom or mommy or whatever the case may be, that's not unusual for a minor child, especially of her age, to use those labels that they hear. Especially when they're around other kids of their age. When they hear labels of mommy, mom, dad, that's not uncommon, especially for a man who's been in her life since she was an infant. Stanley versus Edwards is a decision from 2022. It's a Court of Appeals decision that was rendered March 15, 2022. In this case, a dad tried to change custody and filed to change custody after the original custody order 5 years later. Dad claimed in that case that mom alienated the children. Mom didn't inform him of significant events in the children's lives. He also alleged that mom's morals were questionable, and he attempted to show that she had a number of live-in boyfriends and that mom was working as an escort. Those were the factual allegations in that particular case. The trial court actually changed custody to dad in that case, but the Court of Appeals came back and disagreed. The Court of Appeals indicated and disagreed, this is just last year, indicated that those findings, they disagreed that those findings supported a material change in circumstances as there was no adverse impact to the children. And the Court of Appeals reversed that decision. As it relates to this particular situation, there's been no evidence that the presence of Terence King has had an adverse impact to the minor child. Should I continue, Judge? Okay. And so then as it relates to the next topic or the issue that was raised, there was some issues raised about mom being estranged from her family, in particular, her mother and father. The guardian on day one testified that that estrangement existed prior to the divorce. Now, when she came here and testified today, for whatever reason, 9 months later, it seemed like she wanted to skirt around that. And then she ultimately had to admit that, there was some evidence that the estrangement existed prior to the divorce. Ultimately, the relationship that Ms. King has had with her parents, there's been no evidence that that has affected Ivy having a relationship with that side of the family. In fact, Ms. King testified herself that she assures that Ivy still sees her grandparents and her great-grandparents. She testified that her grandmother just had lunch with Ivy a couple of months ago this year. She testified that Ivy's maternal great-grandmother, which is Ms. King's grandmother, they actually all went to the movies together as a family unit. Ms. King, the great-grandmother, Ivy, and Terence King. They just did that 3 weeks ago. As it relates to Mr. Maynard encouraging a relationship between Ivy and her maternal side of the family, I asked Ms. King, do you support that? She answered in the affirmative. She indicated, in fact, she would drop Ivy off at her mom's house so that way dad could pick her up from mom's. There's been no evidence that Ms. King is withholding Ivy from her maternal side of the family. There's been no evidence that, regardless of what Ms. King's relationship is with her parents, there's been no evidence that it's had a negative effect on the minor child. Now, as it relates to dad, and I'll talk about dad being Mr. Otto Ham, I find it very interesting that on day 4 of trial, the petitioner now brings in the maternal dad to come testify. It wasn't on day 1 or day 2 when the petitioner's side said they rested. They didn't bring him in then. They brought him in on the 4th day of trial to testify after Mr. Ham indicated to this court that he had been watching these proceedings. And I invoked the rule of sequestration on day 1. Mr. Ham indicated he had been watching these proceedings. And so then he comes onto this Zoom screen and he testifies to the court. Now, I understand counsel says she's using him as a rebuttal witness, but I would argue there was nothing to rebut. Terence King didn't mention anything about Mr. Ham. What he testified to is he testified that he had met my client's mother, sat down, had a discussion with her, talked to her about his criminal past because he said she had a list of questions, which is not uncommon for parents. He had a conversation with my client's mother. He informed her of whatever question she asked, he had answers for it. He mentioned that was the meeting. He didn't mention anything about Mr. Otto Ham. So why Mr. Otto Ham was coming as a rebuttal witness is beyond me, other than the fact that he sat throughout the entire proceedings and now wanted to be heard based on what he liked or did not like. It's apparent that Mr. Ham does not have the best relationship with his daughter, and it's unfortunate. He made it very clear on this screen, he does not recognize his daughter as Ariel King. He said, I know that's her name, I don't recognize it. The court even inquired and raised concern, well, not concern, but just inquired about whether there was something more there. Well, my client mentioned it in her testimony. That spanned from when she was a teenager, back when she was 17 years old. Her parents were Jehovah's Witnesses. She was not on board. She did not practice that faith. And she indicated to the court that that started the rift in their relationship. That was well before the divorce proceedings. Fast forward, Mr. Ham said it himself. He does not like the fact that Ariel King was in a relationship with 2 individuals as a trio. He made it very clear that that's not what he liked. He did not believe in that. He did not support that. That's why dad came onto this screen expressing his testimony about what he believes Mr. Terence King to be. But I challenged I urged the court to consider his testimony. He said that Terence King, quote, threatened him and said that he would break his jaw. He testified that was 6 to 8 months ago. The Guardian said when she interviewed Mr. Ham back in November of 2022, that's what Mr. Ham indicated, not that he would break his jaw, that he claims that there was a threat from Mr. Terence King. Well, if there was a threat from Mr. Terence King and a threat to break the jaw, why didn't we hear about that on day 1 or day 2 or even day 3 yesterday? We didn't hear about that until today. I asked Mr. Ham, did you call the police? Did you call the authorities? No. Did anybody call the police or call the authorities? No. Was there any action taken? Nothing. So if it really happened and Mr. Terence King threatened his life and threatened to break his jaw, certainly there would have been some sort of paper trail. But he didn't call the police. The one person he did call was Adrian Maynard. That's who he called. He called his ex-son-in-law. And he had a discussion with him about what happened. Did anybody take any action? Was there any filings thereafter? No. And I asked him, well, what did you all discuss? He skirted around that question. He didn't want to tell the court what was discussed. But the fact that he's coming now before this court on day 4 of trial, indicating that there was some threat made by Mr. Terence King, the overall collective evidence just does not support that. There's no evidence of that whatsoever. He tried to indicate to this court that his wife and his wife's mother were fearful and had issues, where the testimony and the evidence shows the exact opposite. There are exchanges that happens at the mother's home of the minor child. As I mentioned, the minor child and the grandmother or the great grandmother, as well as Mr. King and Miss Ariel King, have all been in the same space, even as recently as a trip to the movie theaters. So when it comes to Dad's credibility and his motive and his objective here today, Dad's testimony is just tainted by the feelings that he had towards Mom's decisions as far as her relationship, and it's also also heightened by the information that he learned about Mr. Terence King. I asked him, how many times did you meet Mr. Terence King? He indicated twice. He met Mr. Terence King years ago. He said that after Mom left Texas, and we know that she left Texas in 2016 because she testified it was when she was 6 weeks pregnant. After she left Texas, he indicated that his daughter moved in and lived with him for a few months and then moved out and started to get her own apartment. Mr. Ham went over there to help her with her apartment. He testified he saw Terence King there at that time. I asked him, was there any interaction? Was there an issue there? He said no, that they barely spoke to one another. Then fast forward and perhaps sometime in 2022, because the Guardian said that she spoke to Mr. Ham November 2022. Mr. Ham then wants to allege that during the second time that he's encountered Mr. King, the second time and only time, he wants to allege that because allegedly Mr. King threatened him, he says now he has a problem with Mr. King's behavior. That's what he told the court. I asked Mr. Ham specifically, do you have any concerns with Ivy living with your daughter? He hesitated. And I asked him again, do you have any concerns with Ivy living with your daughter? He hesitated. And the concern that he had, he said, Terence's behavior. And the court barely heard and said, excuse me, what did you say? He repeated himself. He said Terence's behavior. He didn't say Terence was harmful to the minor child. The minor child is in unsafe conditions, that there is a safety concern, or that the minor child was emotionally harmed. He didn't say any of those things. What he said reflected his own personal feelings about Mr. Terence King. Why? Because he said somebody told him. I don't think he indicated who, somebody, or he heard from a third party about his criminal history. That was the only concern that he had, that Mr. Terence King was, he thought he was too old for his daughter, and that there was a concern about his criminal history. But we didn't hear anything from Mr. Ham about how Terence King came and rescued the day when he took the minor child when the two parents got arrested. We didn't hear anything about that. We didn't hear anything about how Mr. Terence King was there. Like the Guardian mentioned, she knows that Mr. Terence King attended one of the, she couldn't recall exactly what it was, but it was a school function that he attended. We didn't hear anything there. We didn't hear any concerns that Mr. Ham had when, as it relates to the minor child being in Terence's custody when Mom isn't there. When Mr. Terence King mentioned if she's not there, that he would make sure Ivy gets her work done and would take her to the playground from time to time. We didn't hear any of that from Mr. Ham. What we heard was his personal bias that he had. And that certainly was reflected in his testimony. As it relates to the allegations that Mr. Maynard raised as far as the child's clothing, there's an allegation that the child's clothing is too small, that the minor child doesn't wear socks when she's supposed to, she's not wearing a coat, dirty shoes. The court may recall from the evidence that those are the same allegations that Dad raised years ago prior to him agreeing to give Mom primary physical custody. The exhibit 17 that I presented to the court, this was a text message between the parties that took place September 21st of 2018. Respondents exhibit 17. We have text of Dad sending pictures to Mom complaining about dirt behind the minor child's ears. Then he also indicates about her outfits that she's wearing, saying that Mom gave him clothes that are 6 to 12. That were too small. Then Mom comes back and explains to him that the minor child plays, she gets dirty, and then she corrects him about the clothing size. That text took place in September of 2018. Then we see the same text again taking place now. If Mr. Maynard had such a concern about how his ex-wife was caring for the minor child, raising her, the clothing that she was wearing, why did he agree to give her primary physical custody in August of 2019? Why didn't he raise the issue then? We saw the text messages in 2018. There's been no material change. When it relates to the issue of Iyavi's medical well-being, Dad wants to create this issue and create this scene about Iyavi's feet. Mom testified that the feet condition that Iyavi has is hereditary. In fact, Mom testified, and it's unrefuted, that Mom has been the one taking Iyavi to her primary care physician, the doctors that are familiar with her, the doctors that know her, the doctors that have seen her time and time again for the past 6 years. Mom has been doing that. The fact that Dad has concern about the minor child's feet, I'm not faulting him for having a concern. He's being a parent. But then when you take it to the next level to then say that Mom is being neglectful or making some sort of concerted effort to indicate that Mom isn't caring for the minor child's feet, and then to take the minor child not to the primary care physician in Atlanta, but the evidence showed that he took the minor child to an urgent care in Columbus, Georgia, where Dad resides, presented the child in Columbus, Georgia at an urgent care, When he presents the child, of course, he has to let the doctor know what the complaint or report is. And then he lets mom know that based on his presentation of the child to the urgent care, this is in 2022, that now the doctor has prescribed topical ointment. And in the text exchange, we saw that mom was receptive of that. And she indicated that she would apply topical ointment. When she was cross-examined, she even indicated to opposing counsel that she wouldn't have taken the minor child to the doctor. She just would have done just that, applied topical ointment. But then mom also took it one step further, and she indicated to dad, well, she will follow up with the primary care physician. And that's what she did. And she said, based on what she learned back in 2022 from Ievi's primary care doctor, that there was no issue as it related to the minor child's feet, and she did not need to continue with the topical ointment. Well, then fast forward 2023, dad raises the issue again regarding the minor child's feet. And then mom takes the minor child to the doctor in March of 2023. And this was exhibit 46. What Ievi's primary care physician indicates, or her pediatrician, they indicated, quote, no evidence of fungal infection of toes or foot on exam today. Reassured that discoloration of toe is a normal finding. Very low suspicion for fungal component. That was just earlier this year. Mom did what she needed to do to follow up with the primary care doctor. Mr. Maynard just does not want to accept that information. What he wants this court to believe is that there's an issue with Ievi's feet and that it's an ongoing issue. Then he presents a dirty tennis shoe to the court. No feet in it, no dates on it, no indication other than some dirty tennis shoes. That's what he presented to this court. Mom testified that Ievi has plenty of shoes. The guardian indicated she saw a closet full of clothes. Mom testified that Ievi has plenty of shoes, but she knows how her daughter is with playing and getting things dirty, so she would reserve a designated shoe for her to play in and to get dirty. That's not evidence of neglect. Dr. Levy didn't indicate any evidence of neglect. The guardian didn't indicate any evidence of neglect. What dad wants to do here, he told us. He told us on day one. One of the questions I asked dad was specifically, why did you not raise this issue earlier, or in 2020, I think the question was to him, why did you not raise this issue earlier before the court if you had all of these concerns? The court may recall dad went on this monologue for about 2 minutes almost, where he was talking about how he felt like he didn't have enough evidence. He was concerned then back in 2018, but he didn't have enough evidence, and he didn't think that he would have enough to be able to get custody. Then he went on this whole rant about, the justice system and fathers and getting custody and how it's difficult to do so. That's what he told me in response to my question about why didn't you act sooner in 2020 if you had all these concerns. And he indicated that now that he thought he had enough evidence, now he wants to try to have a second bite out of the apple. That's all he's doing here today. As it relates to the allegation about the address change, there was some issues, there was the allegation about mom not providing dad with her address. Well, we saw the evidence. We saw Respondents Exhibit 19. This was dated in December of 2018. There was a text back and forth then about addresses. And in that text exchange, mom indicated, I have to give you an address where the exchange should take place. And that's exactly what she did. And she testified, and Mr. Maynard corroborated, exchange of addresses was not something that they always did because they already had an understanding that they were physically separated. That's not what they always did. Let's fast forward now after the divorce. That was before the divorce. There was an issue raised about the address. Fast forward September 2021, just a month before this case was filed, dad sends a text, and they text back and forth on September 2021, about exchanging addresses. And both parties exchanged. Mr. Maynard then provided his address with the unit number. Mom then responded and provided her address. And then she was served the next month. So in September 2021, they then exchanged addresses. I asked Mr. Maynard on cross-examination because he insisted that he gave mom the address. I said, did you provide the unit number? His response, I don't believe I provided the unit number. So when it comes to exchanging addresses, that's always been an issue raised before this court, before the divorce decree was entered and the custody award was entered, and now, as of September of 2021. I don't believe it's an issue now in 2023, but that issue, again, that's not a material change in condition or circumstances. The issue that was also raised on day one of the trial was the issue of the, quote, changing schools, so to speak, and the issue about having access to records. Now, as it relates to the changing schools, there was testimony that the minor child only attended 2 schools. In kindergarten, she attended Choice Preparatory School. And then the second semester, as I mentioned, she was at her new school, which is her current school. Mom testified, and the guardian corroborated on day one, that the reason that mom changed schools from Choice Preparatory School is because mom was not happy with the curriculum at Choice. She felt that they weren't serving and meeting Ievi's needs. So she made that decision. She kept dad informed. Dad didn't dispute that he had access to the records at Choice Preparatory School. He doesn't dispute or refute that he had access to the records at the current school. Mom indicated that she wanted to be a better curriculum for Ievi to thrive. And she also indicated that based on communications with her daughter and having a set of friends or peers around her, she thought it would be better to then put her in the public school. And we all see that that decision has been working to Ievi's better interest. As it relates to the school records, Ivy, the testimony is that mom did change daycares for Ivy before, but as it relates to the main daycare that has been at issue, Lifeline, that was an actual daycare where Ivy was attending. The school was closed for a period of time and then reopened. The evidence showed that dad went to the wrong location that was closed. Mom gave him updates about what's going on with the daycare and that Ivy is actually physically in daycare at a different location. Dad goes to the school, and what happens? The unrefuted testimony is dad acts a fool at the school. The police had to be called. Dad acted out. The director of the school refused to cooperate thereafter. Dad showed up, presumably under the guise of picking up Ivy for his birthday visit, but he didn't leave with Ivy. He left her there. Not only that, he had yet to get any records because he did not submit the documentation that he needed to submit. Mom testified that she informed Dad he needed to complete the proper intake form, give it to the daycare so that the daycare could do whatever they needed to do with him because both parents had to do that. I asked Dad on cross-examination, did you complete the documentation? He claims he didn't hear back from the school, but then I cross-examined him and asked him, well, did you take the completed documents in hand and give it to the director when you went to the school? And he said no. All he did was show up at the school and cause a scene. My client even testified today that the daycare director at Lifeline, at that point where mom had to change the daycare director wouldn't even cooperate with us during the deposition and during this proceeding, all because of how dad reacted and showed out when he went to the daycare. That's what happened with that daycare. As it relates to the issue of this, I guess, allegation that Ivy has suffered burns or blisters and cuts, dad wants to parent through Ivy. He doesn't, and through the courts. He's not parenting with Miss King. He's not reaching out to Ms. King saying, hey, what's this red mark on Ivy? Or let's talk about, how you're teaching things with Ivy in your household and how we're going to raise her together and address some of these things. Because mom testified, and I asked Dr. Levy about this, mom testified that she incorporates a Montessori style of teaching, that her goal is to help show Ivy how to become independent. Her goal is to teach Ivy based on hands-on learning. And I asked Dr. Levy, did she have a concern about Montessori teaching? And she indicated no. And so what my client testified to here today before the court is that the burn that Ivy had, mom was present. Mom indicated she was present. Mr. Maynard wasn't in the household, so he doesn't know what happened. Mom indicates that she was present and that she was overseeing Ivy. And when they took the food out of took the tray out of the air fryer that was greaseless, that Ivy's arm touched a hot pan, and that's how she had a red mark. There was no indication that it was an emergency, that she had to be rushed to the ER. In fact, there was no indication or evidence that defects had to get involved, or that it was anything other than red mark that was from the air fryer. Then dad wants to present evidence of Ivy's hand. New evidence from 2023, while this case has been pending and we've been having this multi-day trial, dad then pulls in new evidence and says that the hand that, or the allegation or questioning of mom was whether or not there was a blister on Ivy's hand, as far as it being related to a burn. Mom indicated that Ivy rock climbs. She's an active kid. She rock climbs, she plays in the dirt, she plays on the playground, and that because she rock climbs, she will get blisters on her hands. But mom took corrective action and she purchased gloves for Ivy. That's what she mentioned. Those aren't signs of neglect. Those are normal instances that happens with children who are 5 and 6 years old and a parent being responsive to those. But as it relates to the issue of co-parenting, at the end of the day, it's clear that there's been some bickering and fighting that has existed even before the divorce. We saw the text messages. We've heard the testimony.
Sorry, how much more time you have? Because I think you're probably really close to the hour. So an hour. So you're probably 2 or 3 minutes from it.
Okay, I'm going to. I was literally on my last 2 points or topics.
You got.
I'll fast track. I'm sorry.
You got a few minutes. You got a couple of minutes.
Okay. As it relates to the co-parenting between the parties, the evidence has been clear that there's been ongoing bickering between the parties. But the case of Popes versus Popes, that particular decision indicates that parental discord that existed even prior to the custody award is not a material change in circumstances. That citation is 833 Southeastern 2nd, 554. That is a 2019 decision for the court's review. And that's exactly what the evidence has shown here today, that if there is ongoing bickering and discord between the parties, that's not a material change in circumstances, especially if this existed before the entry of the last custody award. But I will go on to state, even if there was some sort of indication that the court believed was a material change in circumstance, the second test or the second prong of the test deals with best interest. So even if this court found that there was a material change, it would still not be in this minor child's best interest to uproot her. The guardian gave her feedback to the court that she thought that there should be an immediate change. And that's concerning when the last time that she saw the child was almost a year ago in January of 2023. The evidence showed that the father does not support Ievy's interests. He has yet to go to the school for any of her functions, despite the fact that he has access and opportunity to do so. He has yet to go to the father-daughter dance with Ivy. He doesn't support her acting, her singing. He wouldn't sign the papers for her to participate in the acting agency. He wouldn't sign the papers for the passport so that way Ivy could have an opportunity to act overseas. Dad lives in Columbus. There's been no evidence that Ivy being uprooted from the area that she knows, her community, her friends, her support system, the school where she's thriving, the activities that she's been involved in, there's no evidence to support that moving her from all of that will be in her best interest. And so we would certainly ask that the court finds that there has been no material change. And even if there was some sort of material change that the court finds, that the court denies any change in custody and change in parenting time. There was no evidence of any financial status or income of the parties. So to the extent that there's an allegation that there's been some sort of substantial change as it relates to child support, there's just been no evidence of that. So the court does not have what it needs to even make a determination of whether or not there's been a substantial change in the child support. And then lastly, the contempt issue. The contempt issue, when it boiled down to it, Mr. Maynard.
Your hour is over.
Okay, and we would just ask the court to deny the contempt and reserve the issue of attorney's fees.
All right, so it's 5:47. We'll have to end for tonight. And start tomorrow morning. Figure out when.
Wait, come again? I'm so sorry. Are we logging on at 9?
I'm about to figure out when. I gotta look at what I have. What I'm doing tomorrow morning at 9 a.m. And we'll do the closing. Finish the last part of the closing.
All right. Understood, Your Honor. Thank you so much.
All right. Thank you, Judge. We appreciate your time.
All right, you take care.